My lord, I will also kindly to mention some matters for inclusion in your lordship's list, my lord.
Please, no motions, please give slips, don't mention. Motions will appear as the file comes. Please give the motion mentioning slips. They'll appear. Please don't mention.
Lordship, my case is in September monthly list, and this is a GST matter. My application for waiver has been rejected. There may be a recovery proceeding. This is renewal apprehension. Kindly consider my
It's
prayer.
appearing in the list or not in the list.
No, it is a monthly
Please
list.
give the slips which for motion. Please.
Ready for reading the extension of last extension of
30th November. 30th November. It is still time. Still have time.
We have time.
My lord, may I have your lordship's kind leave to mention a writ petition, my lord? My lord,
For hearing or
yes, my lord, it is ready for hearing. My lord, what has happened, may I just indicate? My lord, subsequent to the filing of the writ petition, my lord,
give your grounds of urgency and give the slip.
my lord, perhaps, my lord, sorry, my lord, perhaps, my lord, the subsequent events have taken care of the grievances because of which I had filed the writ
You
petition.
want to withdraw it?
Yeah, my lord, not really withdraw it, my lord. Your lordship may perhaps look into the subsequent events and dispose of the writ petition. My lord, my grievances have been largely taken care of. My lord, I filed an application to that
If you
effect.
want it to be adjudicated, that is one thing. If you want to withdraw, that is other. Because if it has to appear in the hearing list, it has to wait till it's turn.
Yes, my lord, I filed an application to that effect. My lord, I need an adjudication, perhaps not just withdrawal. My lord, the subsequent events, my lord, must be.
Wait for your turn because there are other urgent matters.
That's all right, my lord. There's an application also. May I just hand it over for inclusion? Yes, I'm so grateful, your lord.
Extension of independence is expiring. Very well.
My lord.
Extension গুলো আলাদা করে রাখুন কিরকম expire. Please write the date on which it is going to expire. You have written it in the slip.
I've written till end of the term.
Very well. That means
My lord, may I be allowed to
very well. They'll appear. You have indicated the date. The extension of entry order গুলো একটু আগে দিয়ে দেবেন আলাদা করে একটা heading এ তাহলে আমরা ইয়ে করি.
May I have Palot's kind leave?
Madam, if it doesn't come on on any proximate date to 30th of November, please mention because for some reason if it doesn't come and the entry order expires, please avoid that.
But hearing of 20 it matters. It was no substantial hard change of determination.
My lord, may I be allowed to mention for inclusion in hearing? My lord, since the date of the first hearing in 2022, there is no other proceeding taken place before this court. And it is a writ petition for service matter. And our petitioners are not are entitled for benefit and they are being deprived of that. And some of them are on verge of superannuation.
May I have Palot's
And
kind
my lord, another matter I need to mention that is also kind of analogous matter, and that is for wrong calculation on the part of higher education department. A large sum of the salary has not been received by our petitioners, and some of them are on verge of superannuation. So hence the urgency, my lord.
You write your grounds of urgency in the slip and then give. Please mention your grounds of urgency in the
My
slip.
lord,
Mention.
yes, my lord.
Challenging illegal search and seizure by the GST
Motion or hearing.
Marat for application, Marat had mentioned this on Friday, and Marat was supposed to directly to serve the other side and come back for mention. Marat, item 216 in Marat system, praying for an upgrade.
You write your grounds of urgency there so that I can see it. I will not.
I will write it, but not.
Please write it and it's motion or hearing, sir? Hearing matter, what is the urgency now? You have got any interim order in your favor? You haven't got any interim order. Please wait. Let us see hearing matters. I have so many motions I have not been able to make any headway. Please wait for some time. specially assigned matter hearing. Specially assigned matters do appear on Fridays. All the matters appear. Then it may not be specially assigned. Please check.
May I, Your Lordship's kind leave to mention this matter, Your Lordship. This matter was heard at length by the previous bench, Your Lordship. Here, the only urgency, Your Lordship, that this is an admitted case where refund is due. I have given several representation to the department, but they are not replying back.
Motion or hearing?
Motion, Your Lordship, the matter was heard. Matter was heard, but it was directed to appear last Wednesday. It did not appear. There was a specific direction by Lordship Justice Kajai Basu Chaudhary to appear on Wednesday. Did not appear.
Returnable of সেগুলো দিয়ে দিন। If there is a
I am
different
deeply
paper, it will
obliged.
appear, it will appear.
And Your Lordship, another matter, Your Lordship, I had mentioned for extension of interim order already last Monday. I had mentioned, Your Lordship, it is expiring, but till Your Lordship, it is not.
এখন কেন আসছে না? When is it expiring?
It is expiring, but it is written in the end of this month, Your Lordship. I had already mentioned this is second time.
Very well. It won't appear immediately. It will appear before it expires.
I'm deeply obliged.
Regarding the non-payment of the benefit, because matter was running for just stated. After the change of the matter has not been out of not gone.
It's in a matter for extension of the interim order. The extension is expiring on 30th November.
Please give the date on which it is going to expire. It will take it
Can application, my lord, can application is waiting for a CH filters the spectrum, relating to filter these two, and in between, my lord, West Bengal government was going to announce once SOD scheme, and instead of waiting to file the under that scheme, that is why my leave is necessary. That is why I filed a can application.
Because I'm mentioning for inclusion in the list because the matter is ready for hearing. Because my vehicle has been arbitrarily been seized, and despite representations, there's no effect to that. Because I'm praying that the matter be listed because it's currently out of the list. It's supposed to appear in a monthly list.
Milad,
So great.
may I permitted to mention a matter for listing for tomorrow, Milad, that's 18th of November. In this writ petition, Milad, it's at motion stage. I have challenged a final finding by the designated authority of the anti-dumping regulations. Milad, similar writ petition has been filed by the importer, challenging the same final findings. That is, Milad, listed for motion stage tomorrow before your lordships. Milad, I have given the name of the writ petition also, IVL Dhanseri Petrochem. Milad, that's a writ petition. We are foreign exporter. We also participated in the same investigation by the designated authority under the anti-dumping regulations. Milad, we have challenged the same final findings. Milad, may be listed tomorrow, Milad, along with the.
দিয়ে দিন ওর সঙ্গেই দিয়ে দিন কালকে একটা কালকে দেয়া আছে না কালকে একটা আসছে কালকে আর্জেন্ট
Should I mention this is a recovery notice? Writ petition was filed in July. It's September. It came in the. It was running in the list. September once the matter was called, but the other side was not there. So it was after that. It has never been called. Now they have issued email for recovery of around 11 crores. Analogy I mentioned last week. I inquired with the court officer. So Lordship was allowed, but Lordship the file.
আনিয়ে নিন আনিয়ে ওটা
That is the issue, Lordship.
যেগুলো মেনশনিং আছে সেগুলো
Department has given email out for 13. I had replied that kindly give me one more week.
সময়ের অসুবিধা ডিপার্টমেন্টে যিনি আছেন
I have prayed for the department till 20th Lordships. Otherwise, I'll again mention.
Well, maybe permitted to mention correction in the order, my lord. My name and a particular section in para 8.
Your names, you please write it properly because
Yes, sir.
names I will not have. Yes. Which section?
Section 107 has to be mentioned in place of 74, my lord, in para 8.
Oh. Non-prosecution দিয়ে দিন।
My lord,
You please bring a letter of. Instead of that, you give it on that day. You just give it for. On the day it comes, you can give the letter. Very well, you give.
my lord, may I be permitted to mention for inclusion in the list?
Mention hearing or motion.
Hearing, group 6.
Give. Let us see. So many.
May I permitted to mention?
After my word, I am supposed to get a compassionate appointment in my application without giving any proper.
Motion. Can't be motion. It's a hearing matter. Then give it. Give all the slips. Let us see.
Madam, may I permitted to mention? May I permitted to mention also, 2 matters was passed in the month of September. My lord, why didn't my lord, 2 matters were passed in September. Wherein specifically direction was there to be appeal authority should be completed the appeal hearing within 12 weeks. My lord, then 12 weeks will be not sufficient for us to complete the proceedings before the appeal authority. My lord, therefore, my lord, I prefer 8 weeks time to extend. My lord, this is dispose of matters. Writ petition number 13852.
No,
and writ
disposed of matter, you have to take out an application if you want extension of time. Yes. List call করুন. Yes, please. ওটা নিয়ে নিন. To be mentioned নিয়ে এসে ওটা রিলিজ করে দিন.
Hearing matter that group 4.
You can give. I don't know when I'll be able to take. List call করুন.
Lordship. Prosecution matter are mentioned.
Item 29.
29 matter.
Give the slips.
I still
Give again. It is not appearing. Please give again.
Okay, Lordship.
Give the slips again.
Okay.
And please bring the instructions from client that you want to withdraw.
Okay.
That letter has to be on record.
Okay.
Right? Passing it over there. They don't have the file. Okay. Next. কেন এরকম হচ্ছে, কেন ফাইল পাওয়া যাচ্ছে না? একটু ডাকুন, বারবার বলছি আপনি ডাকছেন না তো না?
Your Lordship, in this matter, I am for respondent number 1 in this matter for Union of India.
একটা সময় চেক করে আমার তো
Your Lordship, I am for respondent number 1 in this matter for Union of India. I am appearing virtually.
Partially your Lordship direction, my lord,
yes,
we have got the report. In the report, my lord, it has been stated that manual bills of entry were filed. Since manual bills of entry were filed, it could not be processed electronically. Therefore, there is no reflection in the portal
of the IGST.
Yes. Moreover, my lord, we have again tried to ascertain mistakes, these transactions from the account section, which is being awaited. For that one, some further time is.
How much? 1 week will do?
1 week or 10 days, Lordship.
Well, may I get a copy of the report? Because why I am saying so?
If it is not confidential, you can hand
Yes,
it over.
I can give it.
Yes.
Because they are saying that out of my 8 bills of, if my lord take, I will take my lord. They are asking for further time to clarify it. I'm bow down to them. Just one thing I require to clarify so that they can take their instruction properly. I will kindly take my application can for once and kindly come to page number 16.
Can. Yes, can.
Kindly come to page number 16. 16.
Page 16.
Yes. Over here, my lord will find details of my 8 bill of entry.
16.
Right, my lord? Now, my lord, we take their today's report side by side. Kindly take second page of their report.
Second page.
Yes. Now, my lord, the item number 4, serial number 4.
879.
Right. My lord, they have said data not found in the system. Now, my lord, there is a major mistake on my part in my page 16 when I am given the representation. I have also mentioned 107879. Actually, it is 107876.
Oh.
The original copy.
There is a mistake in typing the bill of entry
number. So they have said data not found because 79 was never there. I have wrongly mentioned in my email that number is 787.
So did you not correct it later?
No. Today I can found when their report came, I found data not found. Why? Then when cross-checking we found it should have been
107876. Whether it has been done or not still remains to be ascertained.
Right. So they need to take instruction with
On
respect to
whether 107876, this bill of entry was also
correct. They have to do 76, not 7976. So I would request my learned friend if he can take
So
instruction.
why don't you make a formal,
Yes.
write a formal email then?
My lord, kindly do.
Subject to correction and subject to minor approval. The lordship reflects that in minor order. We'll take instruction.
But that has to be from their end also.
My lord,
May I just suggest one thing, my lord?
One
If you
email.
file a supplementary affidavit within a day's time or 2 days' time.
No supplementary affidavit is required. My lord, what I suggest, my lord, direct me to file.
I'll record his
email.
submission.
Right.
I'll give him liberty to write an email to you indicating that there is a mistake and the bill of entry number should, instead of 107879, should be 76, and then you will respond to that
And
appropriately, and you will take instructions on that also.
You will come up with the report fresh.
Apart from the other instruction that you want.
And allow him the email, let him also, my lord, annex a copy of the said bill of
Correct,
entry.
correct. All. Annexing all bill of entry copy, I will send him an email within 3 days, and thereafter he will come after 10 days with fresh report.
10 days from receiving the email.
Correct. No problem. I am waiting for so many days. Only my concern, my lord, the state government should not go for recovery.
Mr. De, learned advocate appearing for the customs authority, files a files a, what should I call it? It's not a report.
No, it's also, it should have been mentioned as a report. Should have.
Yes. Hands up to court. Files na kore. Hands up to court. A copy of the instruction made over to him by the respondent customs authorities, which evinces that out of the 8 bills of entry, in 7 out of the 8 bills of entries, comma, although
IGST paid, right hand side column.
although manual bills of entry had been filed by the petitioner and duty along with the IGST had been paid, comma, records thereof are there with the customs department, but there is no record as regards the bill of entry number 107879. Full stop, paragraph. It is further submitted that as the payment of duty, particulars of payment of duty in respect of the aforesaid bills of entries have not been reflected in the GST common portal. Therefore, the customs authorities, the respondent customs authorities need to check up with the account section as regards the actual payment in respect of the said bills. Full stop, paragraph. Mr. Chakraborty, learned advocate appearing for the petitioner, comma, submits, comma, on instruction, comma, that the bill of entry number 107879, as mentioned in the petitioner's representation, emailed to the respondent customs authorities on April 26, 2024, within bracket, annexure, within bracket, page 16 of the writ petition, bracket close.
No, application.
Page 16 of Can 1 of 2025, bracket closed, has been mistyped, full stop. It is submitted that the correct number of the bill of entry is 107876 and not 107879. Full stop. Paragraph. Since it has been submitted on behalf of the petitioner that the representation emailed to the respondent customs authorities on April 26, 2024 carries a wrong bill of entry number, incorrect bill of entry number, comma, the petitioner shall be free to make a further representation before the customs authorities indicating the correct bill of entry number in respect of which there is dispute as regards payment of duty and IGST. Full stop. The respondent customs authorities shall be free to respond to the same appropriately. Full stop. As requested by Mr. De, learned advocate appearing for the customs authorities, this matter is adjourned till today we are on 17th.
That will be in the first week, my lord.
First will be monthly list.
No, first week. I'm saying first week.
Second December. Fine. Adjourned till December 2nd, December 2, 2025. In order to enable the customs authorities, respondent customs authorities, respondent customs authorities to check up the particulars of the payment of duty and IGST also. With the account section, relevant account section of the customs authorities. Full stop. The respondents shall, Mr. De shall be free to produce written instructions in such regard on the returnable date. Full stop. List this matter for further consideration on December 2, 2025. At the request of Mr. Chakraborty, a copy of the instructions handed up to court has already been made over to him by Mr.
There are only one more prayer, my lord. But last order, your lordship's last order, 6/11/2025, para 4, last sentence. Your lordship expected that respondent GST authority will not take any further coercive action. That should remain.
That is there.
No.
Achha.
Before the returnable date, it was there.
As has already been recorded in the order dated November 6, 2025, that since the issue as regards payment of duty along with IGST and non-reflection thereof in the GST portal prima facie appears to have happened because of manual processing, as submitted by Mr. De, it is expected that the respondent GST authorities shall not take any further coercive step before the returnable date.
Grateful. Your Lordship, may I record my presence in the chat box?
Yes, of course.
Grateful, Your Lordship.
The instruction to record it in a minute. ওটা বলতে ভুলে গেছি।
না এটা আমাদের
এসে গেছে?
Your Lordship, there is a correction of dates. There is a contradiction of dates about the order passed. Order, uh, in order dated 8 July, it should be 11th August 2025. And against the adjudication date. No, my lord, in the first place, in the first this thing order, last line is 8 July 2025. This is correct. Because for this you have given me liberty to file again. And for again the order dated August 11, 2025. It is again repeated July 8, 2025. In the second page, first paragraph. And against the adjudication,
Set aside.
we have set aside 8 July order, 8th August, 11th August order. Yes, yes. But as this is the first order which is being appearing in the this thing. Then in this
August 11.
August 11. Yes, that I have seen. But yeah, that I have seen. Yes, madam. So I have the liberty to file 11th August order 2025. Much obliged.
Yes. It, 11.
There is for July-August 2025 order, education order is of 1st July 2024. It is 19th. Page number 29. Madam. The adjudicating order is of 1st July 2024. It is written here 19th July 2024. And the second.
Second page, my first paragraph.
July 1.
First July.
My lord, on the previous occasion, my lord had granted leave to the petitioner to carry out certain amendments in the writ petition. My lord, but I have instructions that the council engaged in the matter as a medical condition, my lord, and hence the amendments have not yet been carried out. My lord, I seek a week's time, my lord. My lord, the petitioner
the extension notification under
CBIT
168A.
168A. My lord, that has not yet been done.
Having a break as well as holding it. He बोले 2 सप्ताह नहीं है ना 2 सप्ताह नहीं है
My lord, the petitioner's advocate called me. He was traveling from Delhi. His flight got delayed, so he could not be here today. And my lord, also on the last occasion, I had indicated that no engagements have been issued. So today I got an email that me and Mr. Vipul Kundalia will be engaged, but we have not received the engagement. My lord kindly keeps it next week. We will do it the matter. My lord, I have spoken to him. He is okay with the adjournment till next week.
Lord, I beg to appear virtually, my lordship, for item number 5 for petitioner. My lordship.
এইটা ইন্টিমেশন এখানে ইন্টিমেশন আবার বলছি
My lordship, we could not hear your lordship.
What is the matter about?
My lordship, last time I shown you lordship, I filed an appeal under GST with a delay because I was not aware of the communication, serving of the order and notices. And one of the reason
How
is
many days delay is there?
there is a 230 days delay, my lord. The one of the reason what I have stated in for non filing within time because the order was uploaded in the different dashboard, that is additional notice and order tab. Your
Yes,
lordship has
Chakravarti.
directed the respondent
Madam,
counsel to
this
show,
is-
my lord.
Malad, this is the latest, but these 3 pages I just marked. When this portal was changed, they have not reverted back. But we have got a judgment of the Delhi High Court. Delhi High Court has used the specific date from where this change has taken place. Minor, today there is no problem. If minor sees the 3rd page of
When this writ petition alleges of delay having been
before
caused
that,
before that,
before that period.
then in that case it is genuine.
238 days. But the company minor missing out.
Putting them on terms,
Malad.
pay some costs.
My lord, 10% I have already paid and filed an appeal, my
No,
lord.
that 10% is precondition. This is cost. That is not going to be
My
returned.
lord, my submission, my lord, my colleague will pass on the compilation, my lord. This court has already recognized this problem and directed to pass fresh order, my lord. My colleague will pass on the compilation. My orders are passed prior to this change. Page number 17 is this court order, my lordship, coordinate bench order, where it was acknowledged this genuine issue and orders were set aside wherever this ex
Very
parte
well.
orders.
230 days delay, pay some costs. Don't argue on costs.
My lord, I'm only persuading, my lord, is that this problem is not because of my fault, because of the technical glitch in the portal, which was rectified later. And my orders, in my case, orders were passed well before in 2023. Page number 17, my lord, and 18. Both the decision, my lord, acknowledge that this issue was there. In fact, it was directed the GST portal to GST and to rectify that defect, my lordship. Page number 17, my lord.
Yours is an insurance company.
But Milord, it remains, fact remains, Milord, it has to be communicated to me. I was not aware because there are various dashboard and there is no clarity and any system in place to inform that this is how
Where
the
is your
orders will be.
explanation for delay?
Milord, when I filed my appeal, Milord, I have explained, Milord. It is in page number 85, Milord. I have explained the same reason before appellate authority. 85, Milord, and 86. Both the pages I have explained it.
They have properly explained this, Mr. Chakravarti. This appeal assails
With display in proper tab.
Much of much.
Deep lip.
The Sanal would be more than eager to part with it to get a new one.
Was that matter wherein regarding lordship section.
Whether he is entitled to the benefits of section 16(5). And that was the crux of the issue. But I've got an instruction by through WhatsApp. I've got a print up. That was the date given in the section itself. On this basis, one can remand back the matter to the adjudicator.
Lordship, subject to their instruction, lordship may take page 48 once. Page 48 shows the date when I have taken it. It is 21st of April 2021. It is on record also, but lordship may remand. I have no lordship because lordship in that case I had filed a rectification application in appeal which got rejected. No, now lordship may remand it to the original authority to consider that and allow. Otherwise, lordship.
Yes, yes.
For the April, as your lordship. Just I can show lordship page 48 the table.
Notices, judgment on notices.
Lordship, I filed my GSTR 3B of March 21 quarter on 21st of April 21, which is at page 48. In page 48, lordships. Lordship, this is the 3B return for the quarter. Lordship, in top right side may see January to March 21, and this is filed on lordship in the first table 2D, date of year and 21/4/21. Lordship. So in this particular return of 2021 lordships, I have taken certain input tax credit for 1819 and 1920. Now lordships, department on the basis of verification of 2A versus 3B, this particular return was of the view that I have taken excess input tax credit which is not appearing in 2A and 1920 lordships. Lordships, I have given that in my reply in the department notices also. Lordship may take the first department notice at page 53, from which the issue arose, lordships. Page 53 is the DRC 1A at dated 28 to 23. Lordship, the issue was IGST claimed in 3B and IGST reflected in 2B excess ITC claimed in the table. Lordship, to this I replied at page 56. Page 56 is my reply, lordship, and in page 57 I have prepared a table wherein I say that 1819, 1920 this credit I availed in this return in the 2021 return. Now lordship, after that department issued me a show cause at page 59. The detailed show cause starting at page 64. It's the same as DRC 1A. I again replied to that at page 66, lordships, giving the same justification. They passed an adjudication order confirming the demand at page 70. and 75. 70 is the DRC 7, 75 is the one pager order. Then Lordship, I preferred an appeal at page 77 in form APL 1. APL 4, the appellate authority passes the order at page 87, Lordships, wherein the appellate authority says, no, you are not entitled to this. Then Lordship, I file a rectification before the appellate authority at page 117, relying on 16.5 insertion and the board circular under 148 special provisions. Then Lordship, my application got rejected at page 134, stating the issue was Lordship, it is not well.
But I was supposed to come with instruction in this matter. But I request some time. If Malad gives me a week's time, I can come back on Monday.
My lord, can it be made on Wednesday?
This Wednesday.
No, next.
Next Wednesday. Yes.
My lord, another thing is that on last occasion, we had submitted one copy of customs certificate that in support of the fact that it has transported to Nepal. That was not very legible. That's why. Yes. No, not.
there.
Not.
Malad can do one thing. If no, I'll come back. I have some submission. Okay.
Appear for the petitioner. Millet, this matter pertains to millet refund of excess deduction of 2,24,000.
Yes.
175 I have got. 49 and odd amount, 49,000 and odd amount is due from the principal amount.
Well, yes, no, for respect of assessment, they are 6-7, but they don't have any papers. No, he asked. That was asked. Last election.
Millet, I don't have in my custody. I have taken instruction from my client. 20 years back papers. My client don't have. Millet, they are supposed to have their papers in their custody. Millet, they are the authority. And Millet, I am claiming interest of rupees 45,000. Millet.
Understand, but what they have said not that. What should be? My lord. That should 2 weeks, 10 days. I mean,
My lord, was that matter of trans 1, my lord, where the column, my lord, was wrongly filled up, my lord. Instead of 7B, it was the carry forward ITC was in 7A. My lord, lordship has it is fallen from your lordship on that day that after the Philco judgment of the Honorable Supreme Court, whereof the portal was allowed to be open, my lord, for a substantial period of time, my lord. What was the circular? Or rather, my lord, what was the communication from the department as regards to that, my lord? My lord, what to the- My lord, this is a subject guidelines of filing revised trans 1, trans 2 in terms of order dated 22nd July 22 and 2/9/22 of Supreme Court in the case of Union of India versus Philco Trade Private Limited, my lord. Hereafter, my lord, lordship comes down to page number 4, my lord. 4. Paragraph number 4.7. Well, if your lordship remembers that after being disallowed, my lord, that quantum of the carry forward, my lord, the input tax credit, my lord, I went for an appeal, my lord. Appeal has subsequently disposed of against me, my lord. Now, my lord, what was the situation, my lord, as regards to those matters, my lord? 4.7. It is clarified that those registered person who has successfully filed trans 1, trans 2 earlier and who do not require to make any revision in the same are not required to file revised trans 1, trans 2 during this period from 1/10/22 to 30/11/22. In this context, it may further be noted that in such cases where the credit availed by the registered person on the basis of form GST trans 1 / trans 2 filed earlier has either wholly or partially been rejected. My lord, my was rejection, my lord. Has wholly or partially been rejected by the proper officer. The appropriate remedy in such case is to prefer an appeal against the said order or to pursue alternative remedy available as per law. Where the adjudication / appeal proceeding in such cases pending, the appropriate course would be to pursue the said adjudication / appeal in such cases filing of fresh declaration under GST trans 1, trans 2 pursuant to the special dispensation being provided by this circular is not the appropriate course of action. And rightfully I went for an appeal, my lord. My lord, on the last day.
Yes, sir. Malad, before that, Malad, kindly come to for once. Malad, I am grateful to my friend. For once, kindly come to the page 63. Malad, I am referring to the headline 63, the adjudication process. Kindly come to the show cause notice. It has been issued on 27 January 2023. And this circular giving all the of 2023, 27 January 63. Yes, it is the adjudication which has been done in the incident proceedings. It refers to the show cause notice which has been issued on 27 January 2023. This circular giving one-time leverage to irrespective of whatever is there. Yes, Mala. The show cause, I'm trying to my other friends, is at page 48 for your lordship's time perusal.
27/1/23.
27/1/2023.
And then adjudication.
Therefore, during the circular or the period for which the petitioner and all other similarly placed assessees yes, there was no pendency, it was open for all. Irrespective, because of the judgment of the Supreme Court that there may be some difficulty, but that difficulty.
Last time our High Court judgment was placed before your lordship. My lord, Gujarat judgment was also placed, my lord. My lord, Supreme Court was not placed, my lord. If I'm not. My lord, cleared the doubt, my lord. My lord, I'll take 1 minute. My lordship comes down to page number 39, my lord. They are starting from the Sokos notice. Before that, the proceeding was in action, my lord. Page number 39 of the rate. My lord, it is 5th of July 2022. 39, my lord.
Yes, my lord, this is just a pre-show cause notice where he was made aware. He was made aware that you need to pay the amount. Now, during that time, the leverage by the in terms of the notice, the circular was given. So he had ample time to whatever wrong or whatever incorrect measures he have taken. DST DRC 01A. Yes, over here. Yes, over here he has been informed that look here, this is your entire returns payable to the department, available with the department, and you are requested to pay.
I file a reply. I file a reply. Let them not skip the reply. Well, let them not skip the reply. I filed a reply, and subsequently it was in motion, my lord.
My submission will be: I am not a superhuman being that by without the authority of law I will be acting, because I will be checking the record that you did not, your outstanding amount is there. So from this date, from 8 July 2022, he was aware that there is some wrong on his part. Now, before all the authorities are under a statutory forum, under a statutory mandate. Now, this mandate, he is saying that I could not complete it because there is some lacuna or wrong.
My lord, in the circular, my lord, one month time, my lord. Well, 3, my lord. My lord, so packet number 3, my lord. Packet number 3, my lord, of the circular. Well, packet number 3, my lord, page number 2. In accordance to the direction of the Honorable Supreme Court, the facility for filing transfer and trans 2 for revising the earlier transfer and trans 2 on the common portal by the aggrieved registered SSEs hereinafter called as an applicant will be made available by the GSTN during the period 1/10/22 to 31/11/2022. My lord.
Malad, kindly allow us.
May I place the dates, Malad?
Mr. Shopto ke dam pe.
Explain the express matter.
Yes, help us. And retained in the records. দিদি একটু এরকম ধরবো না, কোথায় টেপাটেপি হলে না
Within all matters.
Malad, kindly come to having heard. Perhaps the third page. Having heard. Malad, after the name of councils, Malad, it is a very short order. Malad, having heard, the GSTN is directed to open the common portal for filing concerned forms for availing transitional credit through TRAN 1 and TRAN 2 for 2 months with effect from 1/9/2022 to 31st/10/2022. Considering the judgments of the High Court on the then prevailing peculiar circumstances, any aggrieved registered assessee is directed to file the relevant form or revise the already filed form irrespective of whether the taxpayer has filed writ petition before the High Court or whether the case of the taxpayer has been decided by the Information Technology Grievance Redressal Committee. GSTN has to ensure that there is no technical glitch along the said time. The concerned officers are.
Well, now, my lord, may I place the dates, my lord, which are very relevant in this case, my lord. My lord, page number 39, my lord, lordship comes, my lord. Today, my lord. Page number 39, my lord. DRC 1A. Date is 8/7/2022. My lord, against this, my lord, in page number 42. This is the reply. Sending of reply in part B against GST DRC 01. This is dated as 28/7/22, my lord. This is very relevant. My lord, herein after, my lord, in page number 48, so cause, but 27/1/23, my lord, in between, my lord, my date of reply, which was on 28 July 2022. My lord, how do I know that it was not dropped, my lord? My lord, notice was issued upon me, my lord. My lord, actually, my lord, circular is, my lord, circular, whatever I have placed, my lord, page number 4, my lord, of the circular. 4.7. Last but 4 lines, my lord. Where the adjudication, my lord, I am under the process of adjudication, my lord. My lord, it is a piece of cause, my lord. But it could have, my lord, I had an intuition, my lord, that it could have been dropped, my lord. How do I proceed, my lord? It could have been dropped. My lord, my lord. My lord, our judgment, my lord, yes, my lord. My lord, Calcutta Radio Service versus Radio Service Private Limited versus Union of India, my lord. So you got it, my lord.
My lord, before the judgment, my lord, only one factual correction. I mean, page 41. Page 41 of your lordship is thereafter your lordship will kindly consider Mr. my learned senior friend's judgment. But only the taking into consideration. The words 41 taking into consideration. Only for the proposition that he was made aware that this is your lacuna or whatever is there, you take corrective measures or you pay the money. Thereafter, the circular comes into the picture whereby the Supreme Court unequivocally, without any interest or penal consequences, said that you do the one time. These are my submissions.
My lord, Kerala High Court, my lord. I'll please it, my lord. My lord, paragraph number 1, my lord. My lord. My lord. All good. My lord. My lord, before the first of all, my lord, will place the Calcutta High Court judgment, my lord. My lord. My lord, whereof it was allowed. Same issue, it was allowed, my lord. Thereafter, my lord, there are few more, my lord, which I have not bought, my lord. Second is the Kerala High Court judgment, my lord. My lord. My lord, Kerala.
But in this Kerala,
let me place it, my lord.
I just want to place one line. But, yes, ma'am.
My lord, here, my lord, paragraph number 1, from the 4th line, my lord. 5th line, my lord. The dispute in this writ petition pertains to the denial of ITC that was available to the petitioner pertaining to the pre-GST period, to be precise, for the period from April 17 to June 17. Section 140 of the CGST contemplates that the transitional arrangement of the claim of input tax credit and subsection 1 of section 140 provides that a registered person other than a person opting to pay tax under section 10 shall be entitled to take in his electronic credit ledger the amount of standard credit of eligible duties carried forward in the return relating to the period ending with the day immediately preceding the appointed date furnished by him in such manner as may be prescribed. According to the petitioner, as the petitioner was having input tax credit in respect of the transaction pertaining to the period referred to in above, which were during pre-GST period, they were entitled to carry forward the said credit to the GST regime by virtue of subsection 1 of section 140 of the CGST Act. The initial period fixed for claiming the benefit of carry forward as contemplated under the transitional provision in section 140 was 27/12/17. However, later on, as per the direction issued by the Honorable Supreme Court in Philco Trade, the time limit was extended up to 30/11/2022 for all the taxpayers. The petitioner submitted Exhibit P7 form GST Trans 1, which was prescribed form for submitting the benefit of carry forward under section 140 of the Act on 30/11/2022. The last date on which the same ought to have been submitted. According to the petitioner, the application could not be successfully uploaded as certain errors were shown in the portal. Accordingly, the petitioner raised the grievances on 1/12/2022, my lord. My lord, admittedly, there was a technical glitch, my lord. But, my lord, this court, my lord, thereafter, my lord, paragraph number 9, my lord.
my lord. 9999. Yes, my lord. Yes, my lord. Moreover, in central, my lord, paragraph 9 was I was mentioning, my lord. Moreover, when Central Board of Indirect Taxes and Customs versus Aberdare Technology Private Limited, the Honorable Supreme Court was dealing with the similar matter for the of a human error. In the matter of claiming input tax credit, the following observation was made, Mars. The petitioner Central Board of Indirect Taxes and Customs must re-examine the provision timeline fixed for correcting the bona fide errors. Timeline should be realistic, as lapses defects invariably is realized when input tax credit is denied to the purchaser, where benefit of tax paid is denied. Purchaser is not at fault having paid the tax amount. He suffers because of his
Calcutta
Malad?
applicant representation দিয়েছিল এত
Thereafter, Malad, it was up. And Malad, there are few more judgments, Malad, subsequent to this, Malad, whereof the Honorable Malad, bench number 1, Malad, Chief Justice Malad has allowed it.
representation for অনাতেও 16/11/2022 within
Malad.
Malad, only one factual distinction, Malad, in my lord's Chief Justice order, Malad, para 7, it is factually distinguishable. Malad, once again, the appellate. Para 7. Malad, Chief Justice order.
64.
It was resubmission of Strand 1. Now, the second issue is with regard to the judgment of the
resubmission Tran 1 within the stipulated period
within the stipulated
of the circular.
Yes, within the stipulated period of the circular. Second is the judgment of Kerala High Court. Lordship has finally seen, Malad, why the Kerala High Court has allowed it. Para 12. The petitioner was making an attempt to claim a benefit which it was entitled to as per the statute. Para 12. So on that peculiar circumstances, when after statute he is entitled, but the attempt which he has made, because he has himself admitted in page 44 in his reply to the pre-show cause notice, para 2.2, 2.2, last two lines of para 2.2 before paragraph 3. It tried to rectify the clerical mistake in GST portal on 12/12/2017, but it was not allowed. So on that day, even in the pre-show cause notice reply, he was aware that there is some sort of a clerical glitch on his part in 2017, but there is no factual substantiation that in terms of the circular what he has done, because that merges his right, that his outstanding rights. My submission will be his outstanding rights, or whatever rights he has with regard to the inaction, that ought to have been brought to the notice of the department. If there is a failure on the part of the department, then the law takes its own course for bringing to the notice or for re-rectification or re-correction of the same. He has not done it from 2017. Thereafter, I also leave it aside. In 2022, when the Supreme Court gives, irrespective of any pendency, the Supreme Court directs the the authorities concerned that you have to do the same, and gives a 2 months. My submission, may I complete, therefore, after the Supreme Court's judgment, then it cannot be reopened by the petitioner or by any of the courts with regard to the again relaxing the or rectification of the Tran 1, because Supreme Court's order is ultimately the ultimate, because there has been conflicting views of the various courts whether to open it or not. Various judgments contrary are there. Well, there were at that point of time, there were very contradictory judgments, which ultimately the Supreme Court opened it, because now
Kerala High Court is September 25 judgment.
Let me find out. Give me 2 days time.
And page number 105, of the writ, my lord? From the bottom, my lord, third paragraph, my lord. The applicant claimed that they couldn't file a revised transfer due to receiving the so-called notice on 2/2/2023. This excuse is deemed invalid, my lord. They are admitting it, my lord. I received the so-called on 2/2/2023, my lord. I had tried once. I brought to their notice. I brought to the notice of all the authorities, my lord, even GSTN, my lord. It was not open. The issue was not solved, my lord. Now I was put upon a notice, a so-called notice, my lord, stating that this is not to be allowed, my lord.
Yes, my lord. Let me make. Only on next Monday we shall bring a compilation of judgment and we will not argue.
Grateful.
Lordship, I am for the petitioner, Lordships. Lordship, on the previous occasion, this matter had come up. Lordships, the issue was the appeal was dismissed on the ground of non-payment of pre-deposit. Lordships, the entire tax amount in dispute has been recovered. Lordship, my only prayer in this writ petition was with respect that the appeal petition be allowed to be entertained on merits by the appellate authority.
The only issue that the order is of 2020.
That is the only issue, Lordships.
That is the only issue.
Lordships had asked.
After 2 years, close to 3 years there.
Lordships, I had explained it. At page 10, Lordships, paragraph number 5. a very small explanation, but your lordships, that is
But the limitation was not the issue there.
your lordships, I have attached the, not for that. Your lordships, I have attached the,
Appeal was within time, thereafter, 3 years. उनको why they have to
lordships, the order was passed the 30th of August 2000, sorry, lordships, this was passed on 11th of May 2023 at page 77. No, lordships, 2 years, lordships. Lordships, I have annexed it at page 79, lordships. Your petitioner's own case, your lordships. Lordships, lordships, in most of the cases, the petitioner has no money left with him. Your lordships, what has happened? The inputs are always there. Your lordship, lordship, lordship. Yes, your lordships. Yes, your lordships. Yes, your lordships. Your lordships, many orders. Your lordships, there are many orders, your lordships, for different financial years. That particular financial year, recovery. Your lordships, but the moment our money got recovered, he came to know about it, your lordships. Lordships, the moment the recovery was made, he came to know that at that point of time, the recovery was there, your lordships. I don't know about that instant case. No, lordships, that was not the case, your lordships. Unaware is not the case, your lordships, but lordships, in other cases as well, which is coming up in item number 11, 12. Lordships, for all the matters, recovery has been done, your lordships. It is not the sole case. Absolutely, absolutely, lordships. Absolutely, lordships. That is, lordships, that is the sole thing. He has been suffering from a huge financial crisis. That is the only thing, your lordships. Understood, your lordships. But the moment he could revive, your lordships, then he is taken care of all these. I am completely understand, your lordships, but absolutely, lordships, this has become. But your lordships. Lordships, my only. No, no, it is not the point of being well off, your lordships. Your lordships, uh, the payment in August, Your Lordships. April, Your Lordships. That is true, Your Lordships. I'll be very candid, Your Lordships. Your Lordships, I'll be very candid. The petitioner has not been able to keep a check on the portal, Your Lordships. That is absolutely true. I'm not disputing that, Your Lordships, but the only innocuous prayer, Your Lordships, the only thing is. But Your Lordships, the only small thing is nothing. I'll just make a very small prayer, Your Lordships. Lordships, now that the entire amount has been recovered, I am not. Lordships, may kindly grant some leave to file a supplementary then in that case, Your Lordship. But Your Lordships, may kindly consider that in all the 5 petitions, Your Lordship, the amount has been recovered. Now that he has no remedy available, Lordships, the matter needs to be heard on merits. That is just once, and after that, nothing remains. If the petitioner is not allowed to be heard on merits, then in that case he will be left remediless. Not available. That is the thing, Lordships. And Lordships, now the thing is, since the interest and penalty are also on the verge of getting recovered, Lordships, I'm being very candid. The department has been calling us that if you don't give us any order, we will recover the interest and penalty, and that too from the. As of now, the amount has been recovered from the credit ledger, not from our bank accounts. But the moment interest and penalty comes into play, then it will be recovered from the bank accounts.
This Wednesday.
Grateful, Lordship. Grateful. Lordships, this is a bit delay, Lordships, a bit different, Lordships. Here the matter is delays there, Your Lordships. That hurdle has to be there, Lordships. This is at page.
Justice Doctor has recently delivered a judgment 2024 in connection with Allahabad University matter that no third-party case can be made out. Stick to the pleadings in a writ petition because after Bharat Singh's judgment, just following that, civil proceeding difference between the pleadings, 88 Supreme Court 5.
Your Lordships,
I remember the SCC 884534.
Your Lordship, in this matter, the reasons, whatever has been given to me as a fact, I have written in the writ petition, Lordships, but at page number 20, this is the reason which I have been provided, Your Lordships. At paragraph number 15, page 20, Lordships. Same person, Lordships.
Okay.
Your Lordships, he's basically a scientist. He's
He has
always.
2 forms. What I have my instruction, he has 2 forms.
He has 1 form as of my knowledge.
The instruction is with 2 forms.
Your Lordships, what he does is he's always traveling. He is never in town, Your Lordships. And
Then my
I
lord, he
believe,
is financially equipped. If he is traveling all the time.
and your lordships, what he, I think he's received some grant from the government of West Bengal, lordships.
Reconcile. দুটো form.
Lordships, the appellate order is 10th of November 2023.
Only one.
Lordship, in this matter, the we are challenging the appellate order on merits, which has to be, since the tribunal is not functioning, that is the only thing. My ITC has been disallowed only on the ground for receiving of fake ITC. Lordship, in this case, it's 1.5 years. I'm just, I know, your lordship, it is there, but your lordship, that is a fact.
My lords, Miss, I'm coming against the appellate authority's order. The order was passed on merits, my lords. Since the tribunal is not functional, my lords, may kindly admit the writ petition, my lords. My lords, the only submission here I would like to say 10% 10% tax has already been paid, my lords. While filing the appeal before the commissioner, my lords, 10% has already been paid, my lords. My lords, the only submission, my lords. My lords, my lords, in that case, my lords, kindly admit it, my lords, for now, my lords. If
Lordship, anything? Lordships, for different financial years, the Lordships, the prayers are different, Your Lordships. Explanation is the same, Your Lordships. Same, Your Lordships. Lordships, I'll check it as well. Lordships, Your Lordship, in page number 10, paragraph number 5, it's the financial distress. That's Lordships. In actuality, he is not in town, Your Lordships. He travels a lot, Your Lordships. Lordship, I won't want to comment on that, Your Lordships.
Absolutely.
Lordships, I won't comment on that,
250 is
Lordships.
the court fees. 250 is the court fees.
Your Lordships, but it is, Lordships, it is the same, Your Lordships. Because what has happened, Your Lordships, I'll be very frank. In all the orders, you'll see, Lordships, they have recovered the entire tax amount. Now he's left complete. So I'm not on that, Your Lordships. My point is that since the recovery was made, I absolutely, absolutely. Absolutely, Lordships. Lordships, I'll come up with a supplementary showing the Lordships. This is a case. Absolutely, Lordships. Allowed here. Yes, Lordships.
Yes. Land acquisition matters, there have been.
Absolutely. Yeah. Absolutely, Lordships. Your Lordships, in this matter, the appeal order has been dismissed on the ground of for a delay in filing of the appeal. Lordships, in this matter, the appeal order is dated 26th of March 2025. Lordships, Lordships, I'll just 20 days after 4 months, Your Lordships. 20 days. Yes, Your Lordships. Page 53 and 54 is the condonation application, Your Lordships. Beautiful, Your Lordship.
indicated. The normal principle is applied in the petition. This normal principle is applied in proceedings, thereby directing the aggrieved person to avail the remedies available under the relevant statute, either by way of appeal. To the applicant authority or the tribe. However, in the case on hand, a slight departure is required to be made while applying the normal principle which is being applied while considering a challenge to the classification. But delay is something would be possible if this defined by he could not have gone to the tribunal. Also, because there is a specific, my lord has also recorded as a 1961 Supreme Court judge, and after the delay period, writ petition is not maintained. Yes, he doesn't have any other.
The tribunal is not there.
No, that is not. That is. Yes.
Lordships, in that in that writ petition, that submission is there. That tribunal is not functioning. That is why I'm preferring the writ. Yes, Your Lordship, that is there. The first, I'll definitely have it, Your Lordships. I will do that, Your Lordships. I'll do that. Absolutely.
Mama. Yes. It is down. I mean, we have not been served. We do not know where.
Central GST is answering this. Lordship, here I am challenging Lordships show cause notice, which has finally converted into an order also, on the ground that the order passed is beyond the on the ground that the orders passed are beyond the allegation in the show cause. Lordship, in 2022, an anti-evasion investigation was done throughout the country regarding certain IGST refunds being claimed by exporters, which is contrary to the rule laid down under Rule 96, Sub-Rule 10 of the rules. And it was an all over India investigation. Post that, Lordships, Department issued show cause notices for the purpose of claiming back the refund which the department had granted under Rule 9610. Now, Lordships, in my case, first notice was issued on 22/11/22, which was replied upon, and finally the show cause came to be issued on 5th of August 24. 5th of August 24 under section 74, alleging suppression. And this is the refund which the department has granted me already. Now, Lordships, I reply to that particular show cause reply. Now, the adjudicating authority, out of the major demand, drops the demand of 2.54 crore was the total demand, drops the demand of around 1.8 crores and confirms a demand of 70 lakhs on an issue which was never raised in the show cause. I have preferred an appeal. The appeal authority has confirmed that order. Yes, sir. And my Lordship, my problem is that Lordship, Rule 9610 subsequently, the London Adjudicating Authority has already dropped that demand, and it was challenged before this honorable court also in certain petitions, and a full stay was given. In my case, the Adjudicating Authority accepts, yes, you are correct. 9610 is not applicable, he drops. But he takes up a new point, stating that some of the exports that you have done, the export invoices and your purchase invoices, because I'm a trader, Lordship, the purchase is post-export. Say, Lordship, my sale invoice date is 2nd of February. So he says, because your purchase invoice is 6th of February. So he's just comparing the invoice number date. But Lordship, export, everybody of us knows, is depending upon the date of the shipping bill and the EGM. On the day when the goods go out of the customs frontier of India. So the EGM date in all the cases is post my purchase date, because I am a trader. I have issued a pro forma invoice which is dated, because in trading what happens, when I get an order, I raise the invoice on my customer so that I can collect that amount also, and in the same time I place the purchase order. Now that purchase goods comes to me and then I will export. So my final export is after the cutoff date of my purchase only. But the authority does not consider the shipping bill date. They does not consider the EGM date and the net export order date issued by the customs, which means on this day the goods have crossed the custom frontier of India. But Lordship, all these things, they confirm a demand of 70 lakhs. But never in the show cause was a single point of allegation in this. Kindly take the show cause.
But in show cause, my lord, everything has been taken for the financial year 2017-18 onwards and 2021-22. Well, the adjudicating authority found that for a particular 10 these invoices, which are my landed friend, my lord, before purchasing the goods, he issued the export invoice. That cannot be, my lord. He cannot, my lord, be occupied by himself that he knows that the goods will come to me, then I will purchase. How he, my lord, prior he can confirm. That's why he violating the provisions of the PGST Act number section 31. There says, my lord, after, my lord, he could issue the invoices on or before the export of the goods. Well, goods, unless he hold the goods, how he can issue the invoices for export? That is the issue. Main issue is there, my lord. In so-called notice, as a threshold, entire period was there. There is no breakup. But, my lord, adjudicating authority, my lord, sees from the GST.
Page 152. My learned friend has used the term lordship section 31. The violation. Kindly takes page 152 show cause. Whether any such violation was ever envisaged in the show cause. Page 152 onwards is the detailed show cause lordships. May I please? Summary is from 148 lordships. The detailed show cause is 152 lordships. Serial number 1 lordships. Whereas on the basis of the facts, ground, legal provisions stated herein, this notice and the copies of the relied upon documents RUD in short attached to the notice as evidences, it appears that message this and this having principal place of business this, GST and this have contravened the provisions of section rule 9610 of the CGST rules by deliberately availing IGST refunds in respect of the items the supplier of which has availed benefit of notification 48 by 2017 central tax dated 18/10/17 during the period 17/18 to 21/22 to the tune of 2.54 crores and thereby making short payment of taxes. Clause 2. Therefore, the GST to the tune of 2.5 crore appears to be recoverable under section 74. Now, Lordship, brief facts of the case. The investigation in respect of the said taxpayer was allotted to the anti-evasion wing of the Kolkata South Commissionerate. While DGRM report dated this for verification of exporters who have availed refund on inputs either under IGST Act in terms of Rule 96 of the said rules. In pursuance of the same, the investigation was initiated and a letter dated number dated this and din dated this, in which the said taxpayer was asked to submit the documents. List of documents is there, Lordship. The said taxpayer 2.2, why the reply dated this, have stated that they have made export during the period this. Without availing the benefit of notification 48, they have further stated they have received supplies on which benefit of notification 40 dated this have been availed, but they have not availed IGST refund against the supplies on which the benefit of the notification has been availed. They have submitted a document in support of the export made by them in respect of notification dated this. The export documents are duly verified and found to be in order. They have also submitted a statement of IGST refund which they have received during the period from 17/18 to 21/22 along with year-wise refund ledger. However, they have not submitted proper document in respect of IGST refund received by them. A letter number dated this dated 26/23 issued to the taxpayer requesting to submit purchase invoice, export invoice, e-way bill, receipt of warehouse purchase order by them, supporting documents of refund received by them. The state taxpayer again submitted the documents in respect of the merchant export, but did not submit any document in support of export on payment of IGST refund. Again, one more letter dated this was issued to the taxpayer requesting again to submit the detail of item they have exported on payment of IGST and how the items of export were procured and whether any benefit of notification 48 by 17 was availed. The said taxpayer, by letter dated 26/7/24, have stated that they have exported in items of silicomanganese, SC, ferrochrome, ferrosilicon, etc., and submitted some copies of export shipping bills, but they did not submit any document in support of purchase of the items they have exported so far. Thus, the fact is established that the said taxpayer is deliberately trying to suppress some facts from the purview of investigation by not submitting the required documents. Therefore, in order to protect the government revenue, the amount of IGST refund sanctioned to them during the period 17/18 to 21/22 may be disallowed and demanded. The calculation of refund may be disallowed. That may be disallowed given below. Financial year 17/18 to 21/22. In terms of section 74 of the Act, any tax has not been paid or short paid or erroneously refunded, or where ITC has been wrongly availed or utilized by reason of fraud, willful suppression, demand notice shall be served on the person chargeable with tax. So, Lordship, and then the contravention of statutory provision, it only refers to 48 by 17, which is for Rule 9610. The first paragraph of the show cause also stated that I have contravened 9610. Now, Lordship, my reply, page 157 onwards. And Lordship, page 160, what documents I have enclosed, that is also given. Now, Lordship, the demand order, page 161. 161 is the summary order, Lordship. The detailed order starts at 169. (169) is the detailed order starting, Lordship. Discussion finding starts at 174. Because prior to this, Lordship, the show cause copy.
Relevant part at page 177, 5.1.8.
I'm pleased, Lordship. 174 is the discussion and finding. First, 5.1, whether VMPL has wrongly availed the benefit of refund of this by contravening Rule 9610. Lordship, then the page 177. 177 above 5.1.8. Para 5.1.7. In view of the above, it appears that VMPL has received goods under copy of invoices which have suffered 18% GST without availing any benefit in terms of 48/7. So it's satisfied. Now let's see 5.1.8, verification of documents. I have gone through all the documents like export invoices, bill of export, bank realization certificate, procurement invoices submitted by the notice. I am producing my finding as below. Part A. In some cases during 17-18, VMPL had issued export invoices earlier than procurement from metals, Impex Metal and Ferroalloys. And a list is given of 65 lakhs of the refund. 65 is the amount of IGST. I find that export invoice is a document containing the description of the goods or service provided by an exporter and the amount due from the importer. I find that section 31 of the Act, where the supply involves movement of goods, export invoice to be issued before or at the time of removal of goods for this. Now let's see part B. He also notes down certain invoices wherein he calculates the entire amount. Accordingly, I find that documents where fit for claiming IGST refund is 1.84 crores. And then he says, in view of the discussion, as mentioned above, I find that said notice claimed IGST to the tune of 70 lakh illegally suppressing the facts to the department and thus the amount along with penalties recovered. Let's if the show cause alleges 48/17, 9610. During that course, he points out a new point, which was never an allegation under show cause. And all these documents were provided beforehand. And let's if the part that let's if he is only taken in the table invoice date and invoice number. Knowingly, the shipping bill number and the shipping bill date and the LEO copy has been ignored. Lordship in appeal. Appeal was Lordship not drafted so well, but I will still Lordship, I will submit what is there. Page 184 is the appeal memo filed, Lordships. Page 194 is the from where the statement of facts start. Page 195, para 6. Para 6 and 7. After a thorough review of the legal, page 196, Lordships. After a thorough review of legal provision pertaining to refund, the appellant submitted an impugned order was issued without due consideration of the relevant statutory provision, especially explanation 2 to section 54, clause A, where the explanation explicitly states, in the case of goods exported out of India, the relevant date shall be the date on which the ship or aircraft in which such goods are loaded leaves in. We took this point, you have not considered my shipping bill date and the LEO date. And the grounds of appeal at page 198 onwards, Lordships. All these grounds are taken in detail in page from 198. Now the appellate order. Appellate order starts with Lordship, page 205 is the summary, 207. Lordship may kindly take page 210. Before that, it is the relevant copy of the legal provisions only. 210, para 5.3. I find that contrary to the points of contention of AA, the appellant has come up with clause A of section 2 of section 54 to defend his case, as it is evident from the point 7 of brief facts of the case as well as point 5 of grounds. I find that the said clause there states the relevant date provision is extracted. Last para. I find that such contention has got no relevance with the contention of the adjudicating authority raised in this influenced order in rejecting the influence refund of ITC of this. I find Achuthan has rejected the influence refund as mentioned above owing to violation of 31. Inasmuch as the influence export invoice were not proper and were not fit for claiming refund of this involved in related export. I find contextual is out of context here and appellant has harped on the wrong string without even understanding what contention they are treating here. In view of the discussion, I oppose.
He is appeal. Throughout only question of there is no substitution. Therefore, section 74(1) does not apply. Well, question is that when so-called note, people optional section, the so-called notice, I think, my lord, though section 31 is not there. Section 31 is the, my lord, implication of rule 96(10). My lord, he does not know that what goods he will purchase. He issued the export invoices earlier. Kindly appreciate. Things are here something otherwise, my lord. It is not simplicity. My lord, he issued the invoices, export invoices before purchase the goods. That is the issue. My lord, section 31 they are quoted, my lord, in order appeal, I what we have seen. In order origin also it has been quoted. Tax invoice. It relates to tax invoice. The contents of a tax invoice read with Rule 46. Large. Rule 46 is a detailed rule which provides what are the contents of a tax invoice. Document 1 see 75(7), just one. That will clarify. 75(7) of the section 75 subsection 7. Page subsection 7. The amount of tax, interest, penalty demanded in the order shall not be in excess of the amount specified in the notice, and no demand shall be confirmed on the ground other than the ground specified in the notice. This time in the law, it is basically, and our coordinate bench, Lordships, has already passed orders which I have attached. Lordship, the coordinate bench order is at page 264. The reported judgment. I have judgment of Uttarakhand, Madras also, but I am relying on coordinate. 264. Relevant para good will be para 4 and 5 of the judgment. Here the show cause was for ITC reversal and the demand came for output on the same issue. For instead of ITC reversal, output to be paid. This application, my lord, I think, my lord, does not apply here because you have not can it take para 4.
Lord, in this matter, if your lordship only takes up, my lord. Now, my lord, he is asking the appeal order here. But in appeal also, he didn't do this point. He didn't take this point. No, that can you see the appeal? Can you see the appeal? What point he has taken in the appeal? Page 190, can you come over? That is the issue there is all throughout, my lord. The date of what will be the date? What will be the relevant date, my lord? That is the issue he has all throughout well canvassed. He didn't say that so cause notice does not say about this section, section 31 is supplement to rule 96 because he availed the benefit rule 9610. When adjudication was made, there it has been held that if you can issue the export invoices on or before the goods will depart the India. Here he has done, my lord, he issued the export invoices. How can he know which goods he will purchase, my lord? The particulars of the goods have to be given the invoices. That's why he has, my lord, this proceedings was there. Otherwise, other proceedings regarding, my lord, that apart, my lord, on diverse occasions, so-called notice, your lordship will find he has been requested to produce the document. He didn't produce the document. Thereby, the relevant document regarding our export. Kindly see the so-called notice, my lord, time and again. It was alleged in the so-called notice, my lord, 152. Kindly see, my lord. 153, my lord. Para 2.2. The state taxpayer by their dependent solicitors have stated that they have made exports during period such and such. Without availing the benefit of notification such and such, they have further stated that they have received supplies on which the benefits of notification 23rd October 2017 has been availed. But they have not availed any IGST refund against the supplies on which the benefit of the said notification has been availed. Then they have submitted the document in support of the export made by them in respect of notification dated 23rd October 2017. The export documents are duly verified and found to have in order. They have also submitted statement of IGST refund they have received during the period 17-18. However, they have not submitted the proper document in respect of the IGST refund received by them. Then my lord, next paragraph also, my lord, next two lines. Can you say the said taxpayer again submit the document in respect of the merchant export, but did not submit any document in support of the export of payment of IGST refund. Then again, my lord, next paragraph, can you see, my lord, last line.
Lordships kindly takes 2.2, para 2.2, which my learned senior just read. Lordships, I will just clarify, Lordships. Lordship, I will just, Lordships. Lordships. 2.4. Oh, Lordships, I'll go to 177. Lordships. Lordships. Lordship, no. Which is recoverable. This is, Lordship, there is no allegation against me to put me to notice to reply to this. And Lordship, I showed your Lordships that, Lordship, I showed your Lordships the table. They have written in 2 point in the show cause that all the export documents are verified and found to be in order. So, Lordship, how is the scheme of this act? Lordship, may take 2 minutes. I will just explain. Section 54, Lordships, deal with provisions of refund of CGST Act. Section 16 of the IGST Act, Integrated Goods and Service Tax Act, lays down refund of exports, provisions for exports. So if I qualify first under section 16 of the IGST Act as exports, means then I am eligible to claim a refund. Now there are two options of refund, Lordships. One is under section 16, I export under LUT, which is letter of undertaking. I file a letter of undertaking that I will export without payment of taxes. In that case, I am entitled to refund on my purchases, my raw materials which I purchased, that input credit, I will file the refund under section 54. Second option is, Lordship, I pay with IGST. And by making payment of IGST while exporting, though I don't collect the tax, in commercial invoice I don't collect the tax, but while filing the return, I pay the tax. And through the automated process, after 3B filing, within 15 days, that amount is directly remitted to my bank account by matching with IceGate. Okay, this person return and shipping bill is matching. That is the process. Now, when this rule 9610 came, Lordship, there was a litigation. Whether persons who are availing advance authorization benefit or persons who are availing benefits of merchant exporter, they can export with payment of duty or not, or they have to compulsory go under LUT. 8th October 2024, government omitted this rule. And the justification given by the council was, it was put before the GST council, it stated that this rule has created more litigation than favoring the exporters. Now, so the word omission was used. That means, Lordship, it would date back to the original date, which is, it was introduced on 23/10/2017, more precisely. Now, after that, Lordship, in the meantime, all these investigations started all the country through DGRM report. A DGRM report was there, all those who have taken the benefits of merchant exporter and exported with payment of IGST, you should recover. And all these notices, Lordships, come under 74, alleging I have suppressed. So, 3 high courts, Gujarat, Uttarakhand and Bombay, and Kerala, 4, have struck down rule 9610, stating you cannot raise a demand under 9610. 9610 was bad, and once it has been omitted, having reliance to Kolhapur Cane Sugar of Supreme Court, that if any show cause or adjudication is done after 8th October 24, then also it's a nullity, because the day it will date back to the original date of the introduction of the rule. Now, in my case, anti-evasion through DGRM report came to me. I replied, and in the show cause they admit all export documents are verified. So export documents would mean, Lordship, my shipping bill copies, which is LEO copy and the EGM number is there, along with my commercial invoice copy and my 3B, that I have paid the taxes in 3B. They found that to be in order. Once I give a shipping bill, Lordship, I give my tax invoice also. Lordships. Lordship, in the meantime, Lordship, no coercive action, because it's after an appeal order. Lordship may record, because
I'll put some funds to the department.
10% already.
This matter should be hard on epidemic, because various aspects have to be considered here. What my land is saying, my lord. But here, what my landed is arguing in the so called all throughout, the date of what is the relevant date, that is the issue all throughout that. Never he did, and my lord.
No, that's no, day after tomorrow. I thought, Lordship, day after tomorrow. Lordships, day after tomorrow. Lordship. Non-speaking. Non-speaking order. Great.
Your Lordship, I am appearing for the petition in this matter. Your Lordship, my appeal has been rejected on the grounds of delay, Your Lordship. Your Lordship, the delay is 193 days. Your Lordship, my condonation of delay is at page number 87. So, Your Lordship, when the impugned demand order was passed, the company was undergoing the amalgamation process, Your Lordship, and that's why the impugned order went unnoticed. Therefore, the appeal was filed beyond the statutory time limit, Your Lordship. Yes, Your Lordship. Page 87, para number 1.2, Your Lordship. May I read, Your Lordship? Your Lordship, Your Lordship has been kind to condone a delay of 196, Your Lordship, 196 days, Your Lordship. Your Lordship, the process was a hefty task, Your Lordship. Your Lordship, as Your Lordship may deem fit, Your Lordship.
Lord. Well, here, my lord, in this matter.
No, no, no. ওটা কোন পিরিয়ডে কোন পিরিয়ডে?
না 1890 1890
For appellate authority মানে it is for adjudication. But that would be subject to 75(3). My understanding of it is will be governed by 75(3). Just once, see the provision 75 subject to correction. नहीं 75(3) में भी होता है ना, दो साल
Demand के लिए 107 it says may pass orders within 1 year, so it is not compulsory.
If I'm not wrong, my lord, 107:11, my lord.
It is
Yes.
that is always
Yes, yes.
that is always.
Adjudication order passed, my lord, for the year 2021 under section 73, my lord. And the delay in filing appeal from the outer limit of 4 months, my lord, it is 26 days, my lord. I leave it upon your lordship, my lord. And the reason, the explanation has been given, my lord, in page number 47 as well as paragraph number 9, my lord, that he had a spinal injury, my lord. The doctor's certificate is in page number 52.
May it please your lordship, Lord, I'm appearing for the petition. Lord, this is not challenges not the assumption of jurisdiction under section 148. Lord, the assessment here is 2019-20. Lord, the petitioner Lord, is a manufacturer of coal tar pitch, carbon black, and such products. Lord, the raw materials are the liquid in liquid form. Lord, the liquid coal tar, carbon black feedstock. So they use a particular transporter called Liquid Gold Carriers Private Limited. So they are transporting the goods from. So substantial payments are made running into crores every year because of this. The basic raw material is carried. So there was a search at the residence of the director of the transporter on 9th of April 2021. And there was survey at the office of that company. Thereafter, some things were seized. A statement of a director was recorded. Thereafter, in the assessment proceedings of that company, for the assessment year 2019-20 itself, I received a notice under section 133(6) inquiring about this aspect. Because the case of the department was that the materials seized, or they went to show that some amount of cash was given back to me. But the precise amount was 80,62,000 or it was given back to me for this year. The transportation charges were some 25 odd crores, but they said that the documents show that this cash was given to me. So I answered that query. I said that I have not received any cash. And and this was in course of the assessment proceedings of the transport company itself. And at the same time, my assessment proceedings for the assessment year 2018-19 were in progress before the same officer. So the same material was put to me in the course of those assessment proceedings about the documents which were seized in the statement. And I gave a full-fledged reply to that. Now the officer completed the assessment of the transporter as well as my assessment, in neither of which this 80,60,500 odd was added. So they accepted, because the stand of the transporter was that the document that you're relying upon does not actually show return of cash. So you are misreading the document, and that is the they had provided me a copy of the reply that is there. So the same officer accepted this particular answer, because otherwise in 18-19 the allegation was 4 crore 75 lakhs. So it was a larger sum. So that assessment, the transporter's assessment for this very year 19-20 was completed. My assessment, for assessment year 18-19, that was also a reopened assessment under section 148. And that was completed after examining the whole thing, no addition was made. Now, ignoring all this, now for the same assessment to 2019-20, they have sought to take up reassessment proceedings for the assessment year 2019, a year which in the transporter's case has been examined. My earlier year has been examined. Same material. Now the only difference is now they have set out portions of the material in the show cause notice. Earlier there was a reference, but the same the document identification numbers are the same. The person's statement is the same. On the same material, they say they have information, and they. So I must point out in the reply which was given, to the notice reference was made of the assessment proceedings in the case of the transporter, because they were up for the same year that I had actually dealt with this allegation, and that assessment was completed because I knew about that. So, but the assessment year 18-19 proceedings were not adverted to. That was something which was not mentioned in my reply. It should have been mentioned, but it was something which is a part of the assessing officer's record. So in a subsequent reply, after they issued the notice under section 148, the one and followed by 142 one notice. So in a reply, this was pointed out that it's a part of your record that this entire thing has already been looked at in the assessment year 2018-19 by reopening the assessment. So you are acting contrary to your own record. So, but this was not before the officer when he passed the order under section 148A3. I must point out, this was because when they initially got the notice, they thought they've already looked into this. So why? So the reply was rather brief, but mentioning about these inquiries made, but not this 18-19 proceedings and closure, that was put in a subsequent letter filed after the 148 note. Not these are the facts before my lord. I can take my lord through the documents. Not the assumption of jurisdiction, but on the same material where they have looked into it in the transporters case. Yes, my lord. Yes, it is that only. Yes, because not when everything has been looked at, not again another. Yes. Lordship, and that is not an assessment made upon due scrutiny, in the sense that this is the only allegation being looked at in those proceedings.
There is no change of opinion. So far as the KDI is concerned, liquid gold, we had information that they were dealing with huge amount of cash. So therefore, search and seizure took place there. But the allegation, so far as the petitioner is concerned, is that they have given checks and taken back cash. There is a difference between the two. The allegation against the transporter is that they were dealing in cash, and therefore search and seizure took place in their place, and they were 131 statements were recorded. Thereafter, the allegation against the assessee is that they have taken cash after giving check.
Lordship, not I will do that. I think that was passing through my mind that I must.
One thing, only one window can be opened. One minute.
No,
No,
my
not
friend
appealing,
is
because
the lack of air conditioning.
I'm sorry if I'm because your lordship is suffering. I can see that, so I don't want the AC to be open. But let the windows be open.
Or that the door, my lord.
Can you do not turn on the AC?
But the door may.
If possible, then kindly open it. Otherwise, not required.
My lord is pleased to have not volume 1, but page 58. My lord. My lord will notice note it is the case of liquid gold carriers, assessment yet. Well, this make a big difference for the court atmosphere itself. but the page 58, not the Lordship. And page 58 note is that notice under section 142(1) dated 17 July 2022 note, addressed to liquid gold carriers. And the precise query, the queries are in the annexure. If my lord is pleased to have the page 60, the annexure. And the precise portion is at page 62, issue 2. cash returned to Himadri Chemical and Industries Limited, now known as Himadri So-and-so. During the course of survey operation conducted at so-and-so, materials data having ID mark so-and-so have been impounded in respect of transportation business of the said group. From analysis of soft data having ID so-and-so, it is found that Liquid Gold has made huge transactions with the SSC Himadri Chemical and Industries, now known as so-and-so. The detail of such income is assessment year 2019-20, cash returned to Himadri Chemicals and Industries against bogus bills raised, 80,62,000. This the transporter with whom I had the business. And at page 62, this is the precise figure, cash returned to the assessee, with my lord. And the reply which was given is at page 64, and at page 65. At the kindly see the new paragraph at the top. Upon review of such incomplete and vague data, it is seen that there is no correlation between actual books of account data. So there's a criticism of the data. Then the next paragraph, the amount specified in said data resembles amount which have been withdrawn from bank as explained above and used to meet the expenses such as fuel, tanker hire, etc. related to tankers earmarked tankers of HCIL. Further, these withdrawals were made from bank to meet various transportation business expenditures such as so-and-so. We enclose cash book. Then, in the said notice, yourself has alleged cash return to HCIL. However, there is no mention of cash return to HCIL in the said data as can be seen from pen drive for financial year 18-19 relating to assessment in 19-20. Hence, the allegations are simply made on assumption and surmises. In no such circumstance where the allegations are made on such incorrect, vague and half-baked data, no addition or adverse opinion can be formed by the assessing officer, as there is no corroborative evidence or link between such rough and incomplete notings and books of account. Then there's other discussion, and then we'll kindly see the last page, page 68. In light of the above stated facts and supporting evidence, there is no evidence of cash return to HCIL as alleged by yourself. Without any cogent material or evidence on record, the data retrieved from pen drive is rough data, wherein also there is no mention of any cash return to HCIL for the financial year 2018-19. Hence, no additions are warranted in the absence of any corroborative evidence to justify the same with books of account of assessee. Further, the assessee has duly justified its contention with supporting evidence as explained above. Now, in course of these proceedings, note 133.6 is issued to me at page 69. The notice is dated 16 July 2022. And if my lord is pleased to see the second new paragraph at page 69. If I may just show the subject note, calling for information under section 133.6 in the case of liquid gold carriers for assessment in 2019-20. Then the second paragraph, during the course of survey operation conducted at so-and-so, materials data so-and-so have been impounded in respect to transfer business of said group. From analysis of soft data having ID marks so-and-so, it is found that Liquid Gold had made huge transactions with the assessee. The details of such income is assessment in 19-20, cash returned to Himadri Chemicals against bogus bills, 80,62,000. And then there are requested to provide the following details. Kindly see the last part, reasons for the cash returned to you by Liquid Gold Carriers Private Limited amounting to so much, along with documents. So this was the specific query. And then my reply is at page 71, that's just the covering letter. And at page 72, I give all these documents, the nature of business transaction, summary of transportation charged by Liquid Gold for different locations, summary of ledger, details of TDS, ledger of Liquid Gold, copy of bills raised against transaction, copy of relevant bank statement, bills raised against the transaction, nature of product transfer, then reason for cash returned by Liquid Gold. Our explanation, we have not received any cash from or any cash returned by liquid gold. So that there's no cash transaction was my simple and short answer. And then the assessment order at page 73. The assessment order refers to the notice issued. I'm not at page 74. Kindly see paragraph 6. The assessment order is dated 26th August 2022 in the case of liquid gold, but for the assessment year 2019-20. And at page 74, paragraph 6 refers to the notice under 142.1 issued on 17 July. That was the notice issued to liquid gold. They were asked that, and that the reply is reproduced here. But the reply, because there were two issues in that question notice. I placed only issue. That the homeopathy should work. This. Lordship. Page 71, the notice, similar that 142.1 notice dealt with two issues. Issue 1, issue 2. Issue 1, he has reproduced the reply, and issue 2, since he accepted it, there is no discussion. He only makes an addition note at page 75 under section 48.3 in respect of cash payments in excess of threshold of 35,000. He makes an addition of 6,05,340. As far as issue 2 is concerned, he makes no addition. He is satisfied. Therefore, he does not do anything. But kindly take at page. If I may take my note back to page 58. 58 at 60. The issue 1 is cash payments. Where it is more than 35,000. This is issue 1 of that notice. Similar at page 61 after the table. He says, in view of the above aforesaid cash transactions violates the provisions section 48.3. So this was the issue 1, and the second issue was regarding the cash return to the assessee, and at page 62. So the assessment order that because he's satisfied with the answers. He's asked me also, and he's done it. Now, if I may take my notes to my proceedings in my case note for the assessment year 2018-19, and if I may draw attention to page 93. But page 93, this is notice under section 148A for the assessment year 2018-19, and we'll kindly have the annex share, page 94. Page 94, information regarding transaction of Himadri with liquid gold. Director Shopon Rai has been received from credible source. Shopon Rai, Director Sonso, having its register of Sonso, is a major transport and logistics service provider in and around Kolkata. It has come to the notice through various credible information that Shopunrai, through his concerned liquid gold, involved in transportation and logistics services, resorting to a large-scale manipulation of books and dealing in cash. Through various credible information received, it has been observed that Shopunrai and his concerns are engaged in generation of large amount of unaccounted cash during the course of its transportation and logistics services. Discrete inquiries also revealed Sri Shopunrai resorted to suppression of true turnover by making large part of sales in Kutcha without maintaining proper books of account and making cash sales out of the books, thus resulting in high unaccounted cash sales income never included in the books of account. It has also been alleged Sri Shopunrai is booking high amount of bogus expenditure in his books of account. The main flagship concern of Sri Shopunrai is liquid gold carriers, having turnover of more than rupees 41 crores in assessment year 2021. Based on the above information, a search and seizure operation under section 132 was conducted at the residential premises of Sri Shopunrai and survey operations at the office premises of Liquid Gold on 9th April 2021. During the course of survey operation conducted at Sonso, various books of account, hard disk, pen drive have seized, impounded from analysis of soft data marked ID LG CPL PD1. It is found that liquid gold carriers managed and controlled by Shopunrai has made huge transactions with Himadri Chemical in industries. It is also found that the details of check of receipt of bills from Himadri as recorded in Excel sheet LG CPL PD1 was tallied bank statement for the relevant period. From analysis of both the impounded materials, it is evident that liquid gold is returning back the amount in cash in parts which have been credited in its bank account by check from Himadri Chemical. The impounded material LG CPL 4 clearly establishes the modus operandi of returning cash back to Himadri Chemical against the bills raised, which is evident in soft copy having ID mark LG CPL PD1. From analysis of impounded material data impounded from Sonso bearing ID marks LG CPL PD1 and LG CPL 4, the total amount of bill raised by liquid gold carriers in the name of Himadri Chemical and Industries during various years is as below. Financial year-wise bills raised by Himadri Chemical in the books of liquid gold. Financial year 2017-18, the total bills were 27 crores 57 lakhs. On analysis of statement, it was found that some bills have been adjusted and amount received in check has been returned back to Himadri in cash. Financial year-wise, return to Himadri, financial year 2017-18, 4 crores 75 lakhs. From analysis of the above data, it has been observed that Himadri Chemical Industries and Liquid Gold is engaged in mutual dealing, wherein check, RTGS, NEFT were credited by Himadri Chemical and in the account of liquid gold against bills raised for alleged transportation of the consignment. The amount was credited after clubbing of various bills, and this credited amount was returned back to Himadri in cash on various dates. This mutual agreement of receiving amount through banking channel and returning back the same in cash is shown through banking channel and returning back the same in cash. During the course of survey proceedings, statement of Sri Shaknik Roy, Director of Liquid Gold, was recorded. From his statements, it was evident that the SSC has clearly accepted that there have been several cash payments made by the concerned liquid gold. It is pertinent to mention that during the post-search inquiry, Shopunrai was given ample opportunity to appear and explain the transactions. However, no explanation was received from the end of the SSC. Therefore, based on the provisions of Section 292C, it is presumed that the contents of the documents seized impounded during the course of search and seizure operation under Section 132 133 are true. From the above discussions and findings, it is hereby irrefutably inferred that the above narrated set of information findings suggest that the income chargeable to tax of rupees 4 crore 75 lakhs has escaped assessment in assessment year 2018-19 in the hands of the SSC. Therefore, requested to show cause. Now, this was replied, if my lord is pleased to have page 98, and the factual part at page 102. It was dealt with one of the points taken was, if my lord is pleased to have at page 103, I had mentioned that the last line of the continuing paragraph, however, these documents on which reliance has been placed has not been provided to the assessee. Not the impounded documents. Next, your good self has placed reliance on the statement of Saknik Roy. However, statement of the said person along with an opportunity of cross-examination has not been provided to the assessee. This was the technical points I took. Then would kindly have at page for the last page note at 109. The paragraph in the middle, without prejudice to the above. The first part note dealt with that lack of satisfaction. Then, without prejudice to the above, it is submitted that the SSC company during the year had engaged various transporters to transport its raw material from various destinations, and its manufacturing plants, among them Liquid Gold, is a transport company which was engaged by Himadri to transport its raw material, namely liquid coal tar, carbon black feedstock, etc., and liquid from various steel plants like Durgapur Steel Plant, ISCO, Bokaro Steel Plant, Tata Steel, imported raw material from Haldia, etc., to its manufacturing plants at so and so. The expenses incurred towards the said transportation of raw materials are duly accounted for in the books of account of the SSC company as carriage inward, and the amount and the payment for the same was made through proper banking channels in respect to the bills raised by the various transport companies. Therefore, it can be said that all observations as discussed in the above referred show cause notice are based on assumptions, and no irregularity on our side is visible. Under the facts and circumstances provided in the reply, no income has escaped assessment during the year amounting to 4 crore 75 lakhs. Now, thereafter, the order was passed at page 110, and that order repeats the show cause notice. So I don't need to trouble my lord with that, but they rejected my stand, referred to the same material that PD1 and 4, and this order was passed. Notice under 148 was issued page 114, and then in course of those proceedings, kindly take note the 143 to 142 notices at page 116. But this is the notice dated 25th May 2022 under 143.2 for the assessment at 1819, and page 118 is the annexure. And just to give a glimpse, page 119, the same figure 4 crore 75, that cash is there. The allegations are repeated, and then kindly take note page 127. This was the notice under 142, also 25th May, 127, and in that at page 128, in the annexure, serial number 5, please furnish trade relationship and details of transactions with Liquid Gold, managed and controlled by Shopon Rai, and then other details relating to transactions with this company. Under 5, there's fresh serial numbering, 2, 3, etc. And then the reply which was given at page 131. At page 134, the last paragraph. Before that, I took my points. I have not been given copy of the state documents. I have not been given copy of statement. Yes, I'm grateful. Page 155 is volume 2, and yes, now interesting part is kindly take that 155. The order is dated 26th of August 2022 and passed by the officer of assessing officer Central Circle 3-4. The same officer who made the assessment in the case of liquid gold. But their assessment was made on 26th August, and my assessment was also made on 26th August, same day. Now, this proceedings has started at page 166. 166, madam. The in annexure note, this is the fresh one, but for under challenge before madam. The annexure note 167. This office has received credible information in accordance with risk management strategy formulated by CBDT in case of Himadri for assessment in 1920. As per received information, Shopon Rai, Director of So-and-so Liquid Gold, having its registered office at So-and-so, is a major transport and logistics service provider in and around it is referring to the same documents and the same Lordship. Yeah. So it is the same document, the same statement. And what it is coming from the same central circle 3/4. So they have not looked at the well, what they probably did not do was look at their own record. They've acted on the same information. It was for several years that they 1 year they have reopened and have been satisfied. So then it has to be put to an end. Without referring to their own record, they have.
The only thing that I want to show you, Lordship, because I don't want to take your Lordship through all the papers at this stage, because this is not a case. This is not a case in which the read court should interfere at this stage, because after the assessment order has been passed, yes. Subject to correction. There has been a search and seizure at somebody else's place. Yeah.
1920.
Now, Millard, kindly take page 186. I'll show you only one thing and then I'll leave it to your Lordship. You'll kindly take page 186. This is the order under subsection 3 of section 148A. Now, Millard, kindly take page 189. Here, Millard, the assessing officer has, Millard, tabulated the amount of profit or the amount of transaction between the parties, between liquid gold and the assessee. Now, Millard, kindly take only the relevant portion at page 193. Because it is a long order, I will not trouble your Lordship with all. You kindly take page 193 bottom, 6.2. Before that, we'll kindly see the the reply, which is at the mark portion. In this regard, this is to bring to your kind notice that the entire information is based on the search and seizure action conducted in the case of Sri Shopon Rai and survey operation at the office of premises of Liquid Gold, KDS Private Limited on 9th of April. After aforesaid search and seizure action and survey action, Messrs. Liquid Gold was assessed to tax under 147 read with section 143(3) of the assessment year 2019 and 20. During the course of assessment of 147 of the Act, a notice on the 136 of the Act was issued, calling upon information in case of Liquid Gold. Copy of the notice is enclosed. In response, we have filed our reply to your good self on 30th July. Then, my lord, the aforesaid inquiry and verification, your good self has passed an order under 147 read with so and so. In but this is the reply of the SEC. He has replied in this manner. This order has been passed in respect of Himadri, but Himadri's reply is that because you have left behind Liquid Gold, you have let them go, so you should let me go also. Millard, kindly see the letter. Later, Millard, I'll only trouble you with the later ones. The letter is at page 175. And page 176, your lordship will find the entire substance in the last 3 paragraphs. Page 176. 175, your lordship will see that it's a reply to 148A. And 176 is the end of the said letter. The SEC has only said that because you have undertaken this exercise in case of Liquid Gold, so you cannot do it against me. That was what it was before the assessing officer, in front of the assessing officer. But the assessing officer doesn't remember every assessing result. Every case he doesn't. Miller, kindly see page 193, then I will not trouble you. 193, kindly see. The last 62, 63, 64, and 65. Further, the SSC company claimed that the allegation regarding bogus bills have already been examined during the assessment of Liquid Gold carriers relevant to assessment year 1920. However, as per information available in this office, Messrs. Liquid Gold Private Limited has provided cash to the SSC in lieu of check received from the SSC. Therefore, the cash received by the SSC in the income of the SSC and not of Liquid Gold, as alleged by the SSC. It is pertinent to mention here that the SSC company has neither provided any proof of genuineness of bills raised for the Liquid Gold Limited or not submitted any proof of accounts which shows that cash received against those bills by Messrs. Himadri Specialty Chemicals is accounted in the transaction. Thus it is clear from the above and on the record, the transaction are nothing but accommodation entries for routing unaccounted income of the assessee. The assessee has not denied having transaction with Messrs Liquid Gold or any allegation presented before the assessee. Yes. Millard, only thing that I would, Millard, I was thinking, Millard, that whether the assessing officer has to refer to another assessment of another assessee, record of that proceeding in this proceedings. This assessee, but Millard, Millard, but the assessing officer has held that Millard, I understand. Okay, may I come back after 4?
May I be permitted to mention one assigned matter, WPO number 14 of my lord. It is appearing on every Friday before your lordship in the original side. But my lord, every Friday on at the same point of time, lordship also takes appellate side matters, and that those are my lord, being preferred to be called on first. So if lordship on the coming Friday takes the original side matters, because otherwise every day it appears, but it never gets called. But it's assigned matter only on Friday. It was item number 3. Not in today's list, not in, it was there in the last Friday's list, item number 3. So next Friday it will be. Lord, I am not asking for any, only thing is that the lordship prefer that original sign, yes. I understand. The only thing is it deals with a person's employment of a service holder of this court. So that is the reason why promotion and those facilities are without curtailed. Grateful.
Paying for inclusion, my lord, lordship has expressed your lordship's mind that hearing matters to be mentioned after 2 weeks. The only difficulty is when 2024, my lord, opted for VRS, but the dues are not being paid.
Great. Item number 1, 2, 3, and 4 and 5, I believe, my lord, are all the similar matters, my lord. These are matters. I'm in number 3. I'm speaking in one voice with all my.
I want to.
Milord, 1 to 4 are similar matters, Milord. These are matters which have come up for extension of interim order. Milord, the long and short of it is that there is a demolition order which we have all challenged. We are speaking in one voice. There is no contradiction between all of us here in a row. Milord, only thing is we are only praying for extension of interim order.
On the 18th September,
18th September, the order was passed, Milord, which has been successively extended.
18th September lastly extended.
Original
Original order was passed on 29th September 2020.
Milord, only.
So far the affidavits of Calcutta Municipal Corporation, two principal respondents are there. One is KMC and the other is Life Insurance Corporation of India. So far corporation is concerned, I believe the petitioners have completed the pleading. So far the LIC is concerned, Milord, I am praying for more time to file my reply. Milord, opposition has been filed by the LIC.
And Milord, I am trying for.
Number 1 is concerned, Milord, 1253, Milord, both the affidavits will reply, Milord, are lying ready, Milord. I need your lordship's kind, please, Milord, to file it because one of the time is over. Milord, I can file it, I must have.
Yes.
Milord, Calcutta Serological license 1. Milord, that is what I have the petitioner there. Milord, the affidavits in reply, Milord, both, Milord, the affidavit in opposition of KMC and Milord, the affidavit of LIC, Milord, both are lying ready. Milord, kindly grant me please file it tomorrow.
Only one thing, my lord, LIC has not actually served us any copy because LIC, my lord, that is, and because, my lord. No, one.
No.
May it please your lordship. I'm led by learned senior advocate Mr. Abhratosh Majumdar. Learned senior is in some difficulty today and during this week. My lord, kindly have it on 27th November.
My lord, I'm representing the Union of India, respondent number 3.
Stand 7. Father, I'm praying for not today because senior advocate Amit Agarwal will not be present today and tomorrow. Kindly keep the matter on Wednesday. He will be there. Yes, ma'am. Section में बोले दी, टूटो।
Eight, my lord, I. Eight. My lord, the Senior Standing Counsel, Mr. Kaushik Dey is on next, my lord. May a short passover be granted. Nine, my lord, I am for the petition. Sir, here. My lord, October 2018, there has been seizure of gold from my shop premises. Matter was adjudicated. Appeal before the appellate authority was filed. In the second appeal before the learned tribunal, confiscation of the goods, imposition of the penalty was set aside. Now, after passing of the order by the learned tribunal below, we prayed for implementation of the order and requested the authority for release of the goods. Now, they were not releasing the goods, eventually which led to filing of a writ petition. My lord will kindly take page 126. This is the order passed in the previous writ petition, my lord, whereof the order of the learned tribunal was directed to be complied with. Now, my lord, thereafter, at page 128, department made intimated on 1/1/2025 that the, my lord will kindly take the page 128. My lord, the second and the third para. Now this office has received a High Court order dated such and such sent by email by HQ Law on 27/12/2024, wherein it is ordered to comply with the SESTAT order within 1 month from the date of the order. Further, it is seen from the office records that the gold, 6 pieces, has already been disposed of and intimated to this office on 21/3/2022. Now, my lord, I take back your lordship to the order of the tribunal. At page 122, this is the ordering portion. My lord, page 122, this is the running operating portion of the order of the tribunal, my lord, para 9. Therefore, respectively relying on the aforesaid decision, I hold that the gold in question cannot be confiscated. Consequently, confiscation of gold in this case is to be set aside and no penalty is impossible Now, my lord will kindly take the Customs Act for one, section 126. Lordship. My lord. My lord, may I read for your lordship? My lord, section 126, on confiscation property to vest in the central government. Where any goods are confiscated under this act, such goods shall thereupon vest in the central government. Next section, the officer adjudging confiscation shall take hold of the possession of the confiscated goods. Now, my lord, the order of the learned tribunal is passed on 15/7/2024. Confiscation order is set aside. Before that, they treat the order of confiscation and vest it with the government and dispose it. Now, my lord, what they do eventually, they thereafter, my lord, will kindly take the order in original that was passed, by which the return of the value of goods was made. It starts at page 131. My lord, the relevant will be at page 133. At the bottom, my lord, para 3.4. The Deputy Commissioner S&D CCP via their letter dated 15/1/2025 informed that the quantity of gold in respect to the mentioned seizure case weighing such and such has already been handed over to SIMPL and via HOGS note number such and such dated 13/1/2022 in compliance to the board's instruction number 27/2021 customs dated 3/12/2021. And since gold is already disposed of by way of handing over to SIMPL, refund of the value of gold is processed as per instruction number 22/2022 dated 16/6/9/2022 as per the rate prevalent on 13/1/2022. My lord, I say this is erroneous because I have never been disentitled from my entitlement over the goods, and my last attempt to succeed on the ownership on the goods culminated by the tribunal order when it was passed in 15/7/2024. Therefore, by way of their disposal in 2022, cannot render me for the value that is fetched as on 2022. I am entitled to it as of the order passed by the learned tribunal. Now, my lord, he calculates the value. My lord will kindly consider the table. HOGS note dated 13/1/2022, weight as per note 996.1820, the rate of pure gold. Now he calculates the rate as of 13/1/2022. Well, this is one part of my argument that I am entitled to more of the value. Now, kindly take to the my lord seizure list, which is at page 7 of the writ petition. Page 7 of the writ petition. No, my lord, page 30, my lord. Page 30, my lord. My lord will kindly see, this is the seizure list. My lord will kindly see the last table, second column, my lord, quantity. 6 pieces, total weight 997.99 grams. And what they are refunding, my lord will kindly compare this with page 134. 996.820. There is a shortfall of 1.17 grams. My lord, firstly, I am entitled to the value of the gold as on the order of the tribunal, which was passed in 15/7/2024. they deprived me of that value, saying that the gold was disposed of. Disposal of the goods are subject to raising of objection. I raised objection that my appeal is pending. The matter has not attained its finality. Therefore, you cannot dispose it. That I will show that that is annexed. Now, my lord, they consider this disposal date as 13/1/2022 when they handed over to SIMPL, and they calculate the value on that day on a lower quantity, which is 1.17, even lower to the actual seized goods. My lord, my respectful prayer before your lordship here is, my lord, directions may be passed to immediately release the remaining 1.17 gram or the value it fetched as of the current market value. And in respect of the valuation that has already been determined, as on the considering the date of disposal as 13/1/2022, fresh valuation be made with as on the date of the order of the tribunal, when I became entitled for the release of the goods.
Kindly allow me a portion.
नाम का भी है।
Issue is very short, my lord. We prefer one appeal before the against the assessment order before Commissioner Appeal 13 Kolkata in the year 2017. Till date, after that the appeal is pending, no development, no disposed of. My lord knows in the year of 2020, there is a scheme introduced by the CBDT of faceless scheme. But it has not been the appeal file has not been transferred to them. And that is my grievances that, and I'm seeking from the Honorable Court to direction to the appellate authority to dispose of appeal with a town bound manner Because after this appeal, filing of this appeal, it is already, they have admitted that appeal is pending and they have given the peculiar reason that they could not upload all the documents due to the non-availability of the functionaries. That is why the appeal is not pending before the faceless authority, and faceless authority could not dispose of my appeal. Kindly have a look, my lord. It will be clear, the fact will be clear, my lord, from there later, my lord. That a copy at page 13, P13, annexure P13, my lord. Last two paragraphs. They have admitted the appeal is pending. They are saying that, and they have realized the total demand already. They have adjusted my refund. No, there is no notice. Within 4 weeks, my lord, it can be, because we are tracking for the more than 7 or 8 years.
Uh, This is not a challenge to the assumption of jurisdiction not under section 148, but for the assessment year 2019-20. And just to give the background, the petitioner is a manufacturer of polyethylene and polypropylene. This concerns its transactions in respect of one of the customers, called Padme Impex Private Limited. The way the transactions were had taken place was not there's a Delaware agent involved, but Chem Industries, and in terms of that agreement, that agent has promised to guarantee the entire money in the sense that this debtor note is the money is not forthcoming from the debtor note, they have guaranteed the payment of the sale procedure. They get a commission note only after they get the full payments. And in terms of the agreement, they have provided a cash deposit of 1 crore 20 lakh and the bank guarantee 1 crore 40 lakhs. That's so during this particular 6-month period, goods were sent on 25 days. These are of some relevance because there's a confusion which has been created in the order which has been passed contrary to the, but without looking into a fair bit of the documents which were filed. And on this 25 days note, there were 46 invoices raised. On 17 days, there was only single invoice because the goods could be loaded on one vehicle. On the rest of the 8 days, there were 29 invoices. The reason for that was not that either the quantity could not be loaded on one truck, or the goods were from different batches. So if the goods are from different batches, then separate invoices are issued because the batch is identified in every invoice. Because of that, there are multiple invoices in respect of goods dispatched on the same day. Either they would have gone in more than one vehicle, or they would have gone in even one vehicle, but with separate invoices because of different batch numbers. So the total transactions were 7 crore 78,000 odd, 7 crore 78 crores. And the net amount was about 6 crore 59. GST was 1 crore 18. This was the total billing. This was shown in the books of account. The entire money was received on part of the turnover. Return was filed. The taxes were paid. Now, apparently, this Padme Impex, the customer, they were defrauding their bankers. They were having transaction with the unsupported by the clear documents, unsupported by the actual transaction taking place. There's nothing to say. There were bogus billing, etc. So that was the allegation against that customer. The bank initiated proceedings that they were siphoning off funds from the cash credit account. Based on that, and some names were identified. I was not amongst them. It was based on that particular information. They 148 A1 was issued to me. But I would show from the notice that they said, so this entity has done all these things. You have had transactions with this entity. Now, therefore, you give me the following information. A lot of information is asked, including the genuineness, creditworthiness, identity. And then the last part is you show cause why an adverse inference should not be done and this amount should not be added to your asset. And that was the allegation. Because they had nothing. Actually, it was an inquiry being made whether there was a genuine transaction or not, but they given the form of a reopening procedure. So they very detailed reply was filed with documents running into several hundred pages. But the invoices, the waybills, the ledger accounts, bank statements, everything was submitted to so that because they were this 46 invoices, 25 days. So there was a 2-page summary statement where these invoices were also not broken up to show if on a particular day more than one has been issued. So against on that particular day, it was shown that there was more than one invoice. So anyone having a glance at that statement would have seen that there are 25 days of dispatches, but there are 46 invoices because on some days there are multiple invoices. So the ledger account maintained, because not in my books, the ledger account is of the welfare agent because he is the one who has promised the money to me. The welfare agent, their ledger account of that particular customer was also given. So what the welfare agent had done in their ledger in respect of this particular customer, where there were multiple invoices on a particular day, they had made one consolidated entry. So there were 25 entries for 25 days, but wherever multiple invoices were there was a single entry. The figures not able to otherwise tally. So this was also part of the submissions, that ledger and the summary that I had given. Now, in the order which has been passed, the first point which the SSC took was that why are you saying income has escaped assessment? I mean, what is the reason? There's nothing at all in your notice. So please keep it in abeyance till you tell me what is the reason for this particular abeyance. Then I took the point of limitation because this notice is issued after 3 years. And I will place that section 149 1B. There's a specific requirement in the section that when the notice is issued after 3 years, there has to be a certain type of material with the assessing officer in order to issue the notice. And he says that there is such evidence, but I will show what the order really means. So that point was taken. But then the factual part was entirely dealt with. There was a hearing when the assessee had appeared. So he said, please show me stock movement for 1 month. That how the goods actually left your premises, under what documentation. So that entire set was prepared, documents were filed showing the stock movement as to the goods had been taken out of my stock, dispatched, etc. That was fine. Now the order which is passed does not refer to this last reply at all. So then he says finally, in the order, he says the ledger in the books of the welfare agent shows transactions on 25 days. Actually, he writes 24 is 25, but he says it's 24, whereas you have shown 46 occasions. So 46 is the invoice. The transactions are on 25 days. But he says, so therefore there's a mismatch between what you have shown and what your agent is showing. So 46 days, 46 invoices on 25 days, the agent is showing only 24. So therefore this makes it suspicious. Then he says, I have not given any documents to show identity and creditworthiness, but that he accepts in an earlier part that I have filed a copy of the Deltrader agreement, the agency agreement, because my guarantee is there. The creditworthiness, the agent has promised that the entire money will be secured. And as a matter of fact, I've received the entire money. Then he says, ultimately, the allegation is, the order is, or the finding, I should call it, that these are accommodation entries which I have not sale proceeds of the goods. So in the other case, which my lord is pleased to hear, that was the nature of the allegation that you are showing money for services received, but actually it's not, because it's some kind of an accommodation entry where cash has gone back. So this was the allegation which here made is that because the officer realizes that this is already accounted for, he comes to a finding that this is an accommodation entry and not sale proceeds of goods, and which is escape assessment. So this is the completely shifted ground from the show cause notice, ignored the document from record, and has come to this particular finding, which now I will be subjected to a proceeding, which is in my humble submission does not lie. Because no, the first aspect will be the limitation itself. But so my natural justice is also there not non-considered because of the allegation that it's an accommodation entity was never there. I was said why an adverse influence should not be drawn and the that income chargeable tax is escapable. No, that was the if I can look double my note to the but kindly take note volume 1 at page 43. Page 43 note is a notice under 148A subsection 1. Note there's an annexure to this notice, but I'll just read the opening part at page 44. Information was received from Central Economic Intelligence Bureau, New Delhi, by letter date is shown regarding information shared by the Bank of Baroda with regard to siphoning of the fund by Padme Impact Private Limited. Relevant portion and information in this case is as under. There is a summary of it. If I may take my note straight away to the summary, note at page 47. Bottom, the last paragraph at page 47. Based on the information shared by Bank of Baroda, Padme Impact has engaged in fraudulent activities by siphoning of funds from the tax credit account through the use of fake invoices and lorry receipts, along with transactions involving non-existent entities such as Mrs. Polyplast and paper products, Mrs. Montex Packaging, Mrs. Gala Polyimpex. The company diverted substantial amounts, including rupees 20.43 crores to Polyplast Limited, Polyplast and paper products, and rupees 4.13 crores to Montex Packaging between April to June 2018. Additionally, they opened letter of credit totaling 9 crores in favor of Apple Impex, a supplier which was taken there. The company originally proposed to be a manufacturer of plastic products was found to be primarily engaged in trading plastic granules with over 80 to 90% of its business being trading sales. Further, the company failed to submit required stock statements, raising concerns about the legitimacy of these transactions. Moreover, the FCC has not filed return of income after financial year 2017-18. Therefore, it is evident that the SECI has not offered any income for taxation for financial year 2018-19. Further, for financial year 17-18, information has already been uploaded in the state. It is found that Haldia Petrochemicals has made transactions amounting to 6.59 during the financial year 18-19 relevant to assessment of 1920. Therefore, we are requested to provide the following information with all documentary evidence. A write-up on the above information, the directorship on such and such, breakup of all assets held by the company, list of all bank accounts maintained, bank statement of all bank accounts maintained, details of shareholding in the following format, cash book and bank book, write-up on difference, if any, between sales revenue from operation in ITR, sales shown in GST, details of outstanding loans taken in the following format. Then with the next page, please provide breakup of the payment of interest against loans in the following format. 11, details of outstanding loans advanced in the following format. Please also provide documentary evidence establishing identity, creditworthiness, and genuineness of the entity to whom loans are advanced by you, as mentioned in the above table. Please also provide source of funds for the said loan. 12, details of investments in unlisted equities in the following format. 13, ledger of Padme Impact Private Limited in your books of accounts for the assessment year 1920 with corresponding bank statements highlighting the transactions. Please provide all related documentary evidence, for example, invoice, agreement, etc. Documentary evidence establishing identity and creditworthiness of Padme Impact and genuineness of all transactions with it. You are also requested to propose as to why any adverse instance should not be drawn in your favor, and also to explain why a notice under section 148 of the Income Tax Act would not be issued in your case, taking into consideration the above findings. Please note that in case of non-compliance, it will be presumed that you have no explanation to offer. The decision will be taken as per the information available on record. This is the, we're not even actually alleged that income chargeable to taxes is. So that allegation is there in the page 43. The to which this is an annex, whereas that information which suggests that income chargeable to taxes escaped assessment within the meaning of section 147 on account of the following. Information in accordance with risk management strategy formulated in this regard. But the information itself does not suggest anything at all against you. That person has defrauded the bank, and I am not named in that. That is apparent. I have had transactions. That is the sole allegation, factual allegation. I have had transactions. Apart from that, no, there is nothing. Now, the reply that page 79, if I may just show, because that's the acknowledgement part at page 84. Look, kindly take note page 85, paragraph 5.6. The last line of on the page. From the perusal of the interim notice, the assessee could not make out how the action of Padme policy or Padme Impacts Private Limited resulted in a statement of income in the hands of the assessee. In fact, the entire transaction with Padme Impacts has been offered to tax by the assessee. That being the case, the assessee is requested to please let us know the reason how the AO has arrived at the conclusion that income has escaped assessment. Then proceedings may be kept in abeyance. Then with the page 87, the point regarding faceless at the, just trying to see the heading, paragraph 6 at page 87, the faceless and jurisdiction. Then lower down in the page 7, issuance of notice on the 141 is barred by limitation. That point was taken. And then page 89, with the 8, there is no independent application of mine. Then 90. This 19 note is on the facts. A write-up on the above information on Padme Impacts, ledger of Padme Impacts in your book. This note is introducing the requisition in the notice. And then, in this regard, it is humbly submitted that the assessee is a petrochemical company. Its main line of business is manufacture and sale of polymers like PP and so. In the caption assessment here, the assessee has sold polymers to Padme Impact through a delegated agent named Plastic Industries, who is responsible for collecting payments from customers. Assessee follows a pair-based accounting system, recording Mrs. Plastic Industries as pair in their books of account. Meanwhile, Plastic Industries maintain a ledger of Padme Impact in their books of account, collecting the payment from such customer and remitting back the money to the assessee after deducting their own commission. Plastic Industries sends the collections realized from various customers, and with each such remittance, they share an advisory mentioning the name of the customers and their invoice numbers against which such remittance is made. Now, we kindly see the table, which is a kind of index list. In this regard, the relevant documents are enclosed as tabulated here and below. Copies of tax invoices raised on Padme Impact along with e-bills, weighing slips, etc. With copy of Delfrage's agency agreement with serial number 2. Copy of ledger account of Padme Impact in the books of Plastic. Copy of ledger of Haldia Petrochemicals in the books of Plastic. Copy of ledger of Plastic Industries and ledger of Plastic Industries sales register in the books of Haldia. Copy of bank statement highlighting the receipt of amounts in Padme Impact by Plastic in the bank statement of Plastic. Extract the bank statement highlighting the receipt of amount from Plastic by Haldia Petrochemicals in the bank statement of Haldia Petrochemicals. Precedent copies are advisory giving details of all the invoices corresponding to receipt. On perusal of the same, it is evident the assessee has duly recorded sales in its books of account. Moreover, genuineness of sales is established through proper invoices raised along with e-bills. Payments have been received by Plastic Industries and credit agent of Haldia from Padme Impact and thereafter by the assessee from Plastic Industries to proper banking channels. In such case, sales cannot be treated as bogus and disallowed under the provisions of the Act. Then what the other queries are dealt with. All these documents were run into more than 500 pages that was given. Now, thereafter, kindly take note, volume, yes, I must draw attention to that. Yes. But kindly see at page 104. 104 and 105. So this is that summary, my lord, which was a part of the reply. And kindly, my lord, may notice, my lord, that the first column is serial number, and the invoice number, third column is invoice date. And my lord, you notice, my lord, that serial number 1, yes. So, my lord, they have separated, my lord, wherever there is a bunch of invoices on the same day, that is there in a separate group, so to say, and the total is also struck. And then would be, so my lord, that's how it goes. So, my lord, first 4, 6 April there are 4. Then serial number 5, 6, 7, 8, 9, 10 are all single invoices on one day. 11 and 12 are not 2 invoices on the same day. Then there is subtotal for those two. Okay, therefore, this subtotaling is also done. Wherever there are multiple invoices on the same day, the total of those invoices on that day are that has been struck. And then with this, my lord, we see at page 105, there are 46 invoices. But not the days are, the serial number is there, but the days are 325. Now, this is the summary which was given. And look, the kindly take note the ledger, which is not with the kindly take note volume. And just to give a glimpse of the document on page 106. This was the one more thing, Lord, this my Lord, this page. But the vehicle number is also mentioned on at page 104. But there's a column for it, the 4th last column. So wherever there is the, my Lord, you notice what the say page number 3 and 4, they are 2 invoices, but they are loaded on the same vehicle. So likewise, so therefore, wherever there is the same vehicle, for page numbers 22, 23, and 24. 3 invoices, but are all on the same vehicle. That the number the invoices will try to take a glimpse of it, page 106. Can you have a look at section 149? So this is otherwise. May I hand up this? Pilot, may I hand over? My next friend will refer him to. The section 149, 1 deemed no notice under 1 clause deemed. No notice under section 148 shall be issued for the relevant assessment year. C. If 3 years and 3 months, but not more than 5 years and 3 months have elapsed from the end of the relevant assessment year, unless the assessing officer has in his possession books of account or other documents or evidence related to any asset or expenditure or transaction or entries which show that the income chargeable to tax which has escaped assessment amounts to or is likely to amount to 50 lakh rupees or more. The first is if 3 years and 3 months have elapsed from the end of the relevant assessment unless the case falls under B. 3 years, 3 months is a normal period. In order to go to 5 years, 3 months, but the requirement is the assessing officer has in his possession books of accounts or other documents or evidence related to. So this, we must have books of accounts, other documents or evidence related to any assets or expenditure or transaction or entries which show that the income chargeable to tax which has escaped assessment amounts to is likely to amount to 50 lakh rupees or more. So the requirement is that he must have books or documents or evidence to show that he has these entries, the transaction documents are there, he has the entries, those are not being, there must be something related to those in the form of books of account or other documents or evidence which shows that income chargeable to tax is estate assessment of 50 lakh rupees or more. So, that is the part, because there is a lot will find from the order which is passed, he is not referring to anything at all. He is criticizing what I have submitted by referring to part of the submission, but from his own side, either books or documents or evidence that income chargeable to tax in my hands is, which has escaped assessment is rupees 50 lakhs. In fact, not my case, then nothing has escaped assessment. The whole thing is shown. The finding he has given is that there is not sale proceeds, it's an accommodation entry. So the accommodation entry, there are telltale facts. But I've given that entire how the transactions have taken place, eBay bills, invoices, rates. In the order, can take volume 5. At page 701. When order starts earlier, we deal with other things. And then what page 701 was 5.6.2. Despite having substantial sales to Padme Intex, the PC company has not prepared and maintained in its books of account a separate ledger of this entity, which could have facilitated easy understanding of the nature of all the transactions occurring between the transaction parties. In its place, a ledger pertaining to Plascom Industries has been produced, which has recorded all sales made to Plascom Industries, including the sales to Padme Intex. The 74-page document has records of sales made to Padme Intex Limited at 46 different occasions. As no totaling of all sales to the parties made in the said register, the same has been manually done, which shows that sales to the tune of 7.78 lakhs was made during the year. The figure matches with the sales register submitted by the SSC company separately. The SSC company has provided a ledger of Padme Intex in the books of Plascom Industries. This ledger shows that journal entries have been made at 24 occasions, with sales to the tune of 7.78 lakhs 43,000. While the cumulative sales figures somewhat match, there has been a huge variation of 46 as against 24 in respect of the number of transactions reduced into both the ledgers. In fact, it should perfectly match. It leads to the conclusion that there has been a mismatch in occurrence of transactions between the books of the SSC company and the self-ledger agent. No explanation to such mismatch was found in the response of the SSC company. The SSC company was specifically requested to produce relevant documents to establish identity and creditworthiness of Padme Intex and genuineness of its transactions with this company. However, no write-up on this request has been found in the response of the SSC company. Further, no documents to this effect were found with the response either. Therefore, it is amply clear that in the absence of any direct know-how or linkage between SSC company and Padme Intex involved in fake billing, etc., as per the information, it is apparent that funds amounting to 59 lakhs in the guise of sale proceeds is not revenue from operations but accommodation entry in color of sale proceeds. Now, like this, I may point out with paragraph 5.6.3, but This is 46 invoices and 25 days. You write 24, but look, that's a mistake. It's occasions are 25. Invoices are 46. And what this, my lord will notice not the second last line of the paragraph of 5.6.3, 7 crore 78 lakhs 39,960.29. And the figure in the third line of para 5.6.3, 7 crore 78 lakhs 42,610.57. So therefore, there's a difference of 2,650.28. The ledger itself shows, which is submitted to me as part of the record, that 2650 is in penal interest. So it's not an invoice item at all. It's a penal interest. So those two items are 710 rupees and 1939 rupees, adding up to 2650. They're separately there in the ledger. If you take them out, it's perfectly matched. There's no difference between my sales register, the ledger of the then treasurer agent, they perfectly matched. But he goes into this game of numbers, 46 versus 22. That is also easily, but if he had actually cared to look at it, we would have seen it. Now, the allocation now is that in the guise of sales proceeds, there's accommodation entry. And I'll be subjected to proceedings. I'm not on this part. Kindly see at 149 1B, that particular finding that he has given, but at page 701, para 5.4. Okay. Got it. It's not. And not the genuineness, because that party was found that it indulged in fake billing, etc. They were taking money out of the bank. That was the when this data, this document and everything was given, the bank statements are given. They should have actually closed. This was not. Well, but well. But look. But if I may humbly submit, but it will depend on the facts of a particular case. Because in this case, he is starting the proceedings after 3 years. Therefore, he must know that he has to have this in order to proceed. Day after tomorrow? No, we have to second match. Second, we have also in booth number 15, we have matches. I think my lord does take. Lord. Lord. Just that document I think. Lord.
That Passover matter actually for it's tomorrow. Passover.